Hey, what's up, guys? Welcome. Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And, wow. And today, we've got a law news roundup or something. Dramatic yell. Sorry I'm a little late, guys. I was actually sitting in my bed. And I was like falling asleep. It was nuts because it's like 10:30, or it was like 10:30. I had to drag myself out. Thought I was just gonna lay there, passed out, and miss the whole stream. It was ridiculous. Anyway, sorry, I'm getting my tea ready. I suppose I should put a document on the screen. Let me do that. Let me put a document up there. Here we go. Here we go. Done. All right. We're going to talk about that in a minute. Let me get organized here. What a disaster. What a disaster. And by disaster, I mean me. All right. We've got, I think I've got this stuff basically ready to go. Good Lord, I apologize for the lack of professionalism that's happening here. Okay, so I do have a question from D-Ben's Drawn Vids. He said, what is the worst 40K faction and why is it the Tau? It is the Tau. They are the worst. Because they're communists. I mean, they're just walking commies. We got to get rid of them. Absolutely. Okay. All right. So we've got all sorts of stuff going on today, guys. We've got all sorts of stuff. One day I'm gonna post a document explaining why cops suck in green crayon. Yeah, probably. So today I'm sitting there minding my own business. Just minding my own business, and I get a tweet. It says, "Hey Nick, are you gonna cover the Kiwi Farms lawsuit?" And I'm like, "What? What are you talking about?" And so I go, and they had a YouTube link on there. I click the YouTube link, and it's a live stream, and Josh is up there reading this document. Or well, at the time, I don't know if he was reading this document, but he was talking about the lawsuit. And spoiler alert, it was already dismissed. Why is my camera so stupid? Focus here. Eyes up here, sweets. And it was already dismissed by the judge, but we're going to talk about it. I did not get a chance to watch him go through the complaint. So I would like to go through the complaint. We might go through the order. We might not. I don't know yet. But we'll see. And then we've got a Roger Stone indictment. I have to pull that up. I got to find it. Let me start working on that right now here. Party search Stone Roger. Oh my god, there's a million Roger Stone lawsuits. Let me find let me redo that. Party defendant. Oh really? Okay, let's try this one. What a disaster. How many of these? 44, huh? 44. Good job, Pacer. Why can't you sort by date on this? 2019 USA versus Stone. Roger Jason Stone. That's gotta be him. See if we can pull up this stupid indictment here. Arrest. Order warrant. Removal. Oh, come on. I might have to find this in a different place. Just a second. Oh, they removed him to... Here we go. Here's the other one. I got the wrong one. I got the one from Florida, which is just him being arrested and moved here. It says sealed, but it says it's not sealed. See what happens. Oh, it's not sealed at all. It's right there. All right. I know you guys can't see this, and I apologize. Very, very professional. Like I said, I was hoping to have this. Whoops. I was hoping to have this all done, but then I was just so tired. I seriously was falling asleep. Lady Rackets had to kick me out of bed. Roger Stone, Indictment. There we go. Whew. Let's open that while we're here. No, open it. Okay. So we're going to talk about this also. And there's one thing, there's some new there's some news I want to talk about before we get into these legal documents as well. Let me hit the super chats. I apologize. Again, apologize. I'm never supposed to apologize, but I'm gonna. I'm sorry that this wasn't ready. Gojirify asks, why is this complaint written in Comic Sans font? I think you may find out when we start reading it. We might see what's why that person would use Comic Sans. Keck7 Go says the Tau Empire will respect your faith. Kevasa. If only you would listen to reason. Yeah, I don't trust it. Not at all. Merc says, oi, Nick, hit me up at MercMint on Twitter. Might have some work for you. I will do that. And Rick Rekieta says, where is the token black guy that YouTube hates? Rumor has it, the rumor being from him in my communications that I'm leaking right now, should be hopefully the weekend after Valentine's Day. I think the 15th, 14th, 15th, whatever, sometime in there will be when he is able to make it out to the vault. And so that will be when the 15K stream is. And at this rate, it'll be a 15K and 20K stream. And or we'll do 2 or something. I don't know. But thank you all for any new subscribers who happen to be watching this. Thanks for joining up. I stupidly said at 24,000 subscribers, we would do a 24-hour stream. So get ready for that. And since I'm going to need company on a 24-hour stream, get your resumes ready if you want to come on. I will be joined by various people throughout the day, I hope. But I'll start planning it when 24,000 subscribers gets closer. And yes, Marsupial Gamer, I did see the person being investigated for liking a tweet. Absolutely disgusting. But there's the news story I wanted to talk to you guys about, because apparently a bunch of journalists got laid off. And you can tell that a bunch of journalists got laid off in 2019 because the amount of news didn't change when a bunch of journalists got laid off. Because there wasn't any news coming out of these things anyway, right? They were nothing. They're just Twitter. They're just basically Twitter bots. They were the Twitter bots that they complained about constantly. But yeah, HuffPo, BuzzFeed, real good news organizations have just dumped a ton of staff. The BuzzFeed LGBT desk was left with one person. Thankfully, that one person can cover both genders just fine. Oh my goodness. They're gone. Gojirify says FB. Doug Confair says thank you. He doesn't say thank you. I say thank you to him. He didn't attach a message to that. And then he did do a follow-up that said learn to code, which is don't say that on Twitter, apparently, because apparently if you say learn to code on Twitter, you're getting banned. You're getting banned. Maybe they should do a different one. If you don't want to say learn to code, maybe you should just link them to Mike Rowe's Twitter and say learn a trade. Something like that. Because Mike Rowe, he's there to help people who need a quick turnaround in careers. Although I don't know if you can sit on Twitter all day if you have a trade job. I don't know. Can we get a ruling on that? I need some whiskey. Yep. All right. So let's start with this Roger Stone and 19 pages. Let's start with the Kiwi Farms document here. Oh, Anonymous says, show us your feet. And Anonymous says, I finally get the mask I want and I can't even use it. Heck. I don't know why. It's rude. It's rude of me that the masks don't work. Maybe it doesn't think I'm a face. Doug Confair says, I have friends in a union working at a chemical plant, and they definitely sit on Twitter all day. Well, yeah, union jobs. Let's not sugarcoat the union jobs. All right. Should we get into this? Let's get into this. Here we go. Show us your feet. Oh, Bagel Goose. I assume that's you. It calls you anonymous when you do the masks. There's an Easter egg if you can find it on Twitter. There's a feet pic out there of me, just from today. Did you hear about the non-call, Nick? The non-call. What's the non-call? The Orange Cow says, how feasible is it for a president to ignore the order of a federal judge when implementing a policy? It's really feasible. It's just unpopular. I mean, how do you stop them from doing it? How do you stop them? All right, if anybody has an idea, what's a non-call? Jacob, Gulf City, Navo. Send me a follow-up and let me know. In the meanwhile, let me get this document over in my, a little bit better in my view, and let's get started. Let's get to it. All right. What? Okay. The Saints got cheated. In football. In football. No, I did not. I did not hear about the non-call in football. Sorry. It was too cold to go anywhere today, and I've been holed up in my house. Gojirify, where's the quite beautiful Lady Rackets? She is in bed. I hope she's watching, but she is in bed tonight, so that's where she is. But I agree, she is quite beautiful. And Siren Jag says, job definitely frowns on sitting on Twitter thing. The whole thing about possibly killing people if you screw up really makes the company cranky. Yep. You can't do that. Can't do that unless you're a journalist. I think that's how you know if your job is important or not. Is if you are on Twitter during it, will someone die? And if not, I'm not sure your job's important. Okay, so this is a lawsuit, and I might do a video on this person at some point. This is a lawsuit filed by Melinda Scott. This is, if I understand the lore correctly, Melinda Scott's 5th time suing Kiwi Farms or Joshua Moon. And she obviously doesn't know that Mundane Matt is the owner of Kiwi Farms. Maybe someone should tell her so she can serve the right person. Kiss Miss Rekieta goodnight from chat. Rekieta Law. It's difficult. She's a little bit away from me right now. Address the rumors that Josh is a feeder. Well, I mean, I think we know he is. Okay, so this is Melinda Scott as plaintiff versus Joshua Moon. Well, yeah, Joshua et al. Moon as the defendants. This was filed in district court in Virginia. Well, there's Melinda Scott's P.O. box, and don't call that telephone number. Joshua Moon and Brian Zager are the listed defendants. We'll see what their thing is. This is clearly a self-help form. This is a self-help form, so we'll see we'll see how it goes. What is the basis for federal court jurisdiction? Diversity of citizenship. So here we've got so for diversity of citizenship, if you followed along with the Hambly thing, you need to have people in 2 different states or different countries, for example. And you have to have an amount in controversy in excess of $75,000. Oh my goodness. Let's see. So we've got Melinda Scott as a citizen of Virginia, Joshua Moon as a citizen of Florida, and Brian Zager as a citizen of Massachusetts. Tillip says Josh works it to Amber Lynn's cankles. Oh, God, that's disgusting. Ugh. Oh my goodness. All right. Statement of claim. Please see attachment 10 typed pages. No, you see how much space they gave you to state your claim? It's right there. That's how much they wanted. Invasion of privacy. So here's the typed document. 10 typed pages for that statement of claim. El Pao, Peru. What would it take for CWC to have standing against Kiwi Farms? CWC, isn't that Chris Chan? Am I wrong on that? I might be wrong on that. Abaddon the Despoiler. Last time I heard Zeiger was in prison. Did he get out? I have no idea. Don't know anything about him. Bagel Goose says, change my profile pic to your foot. There you go. There you go. Okay, so Chris Chan, what would it take for him to have standing against Kiwi Farms? Well, I mean, the website would have to wrong him or harm him in some way that was not protected activity. That's how. Heavy-fisted. Yeah, there is a point in which the cases could be considered as frivolous litigation. I don't know off the top of my head what that standard would be. Typically in a federal court, it would apply the rule of the jurisdiction where the federal court sits. So in this case, this would be the Federal Court of Virginia. I think it would apply the vexatious or frivolous litigant statute or standards, at least from the jurisdiction from Virginia. But I don't know, because that's getting deep into federal civil procedure, which I don't practice. I don't really do federal court stuff. So I don't want to comment and say it definitely does or doesn't do this. But maybe I can do a follow-up video at some point where I can actually research that and provide a good answer along with a summary of the individual lawsuits. I think that might be a good forum for that. So stay tuned, because I am pretty interested in this stuff, and I like these little 15-minute recap videos that I've been doing lately. So we'll see. All right, invasion of privacy, appropriation. So, well, we'll see what they say first. Defendant Joshua Connor Moon. Footnote. Plaintiff has never met defendant Joshua Moon in person. Joshua Moon is documented in third-party newspapers as an actual person. He's been sued in British courts under the name Joshua Moon. Plaintiff can reasonably assume that Joshua Moon is an actual person. He has a registered business which is documented in the state of Florida. Is the sole owner of a business called LolCow LLC between March 1st, 2017 and September 22nd, 2017. Footnote. After being sued in a state court by plaintiff Scott in June 2017 for appropriation, Joshua Moon did not renew his business license. The case was filed in a circuit court and dismissed. No damages were collected on behalf of the plaintiff. Yeah, because it was dismissed. If it was dismissed, you already have a problem. You have claim or issue preclusion immediately. Oh. But, Josh, if you're out there, isn't it nice to be recognized as an actual person for once on the internet? That's, you did it, buddy. You have ascended to the highest of planes because you're now real again. LolCow LLC was a registered business in the state of Florida. LolCow LLC publishes articles on a website forum called kiwifarms.net. Does the LLC publish articles on a website forum? I don't know that the LLC does. Between March 1st, 2017 and the date of this pleading, kiwifarms.net contains a copyright notice with the symbol LolCow LLC at the footer of the page. Footnote. kiwifarms.net. That's it. The computer used by Joshua Connor Moon to publish for LolCow LLC and kiwifarms.net is controlled from the state of Florida. Which means you got to stay away from that computer. It might rip off your penis and eat your face while you're sleeping. And then it'll get eaten by an alligator. LolCow LLC sometimes uses an IP scrambler to hide the IP from which they send emails. Oh my goodness. On March 14th, 2017, LolCow LLC published an article on kiwifarms.net, which included the full legal name and a portrait of the plaintiff. The article also included links to videos created on YouTube by a New York resident named Andrew Carlson. This is weird. Guys, this is why you hire an attorney. First and foremost. If she's not suing LolCow LLC. She's suing Joshua Moon. So putting out that LolCow LLC publishing an article, that's, if you're suing Joshua Moon, he would have, like, the whole point of an LLC is if she were right on the facts on this, which I doubt. But Joshua Moon would be personally insulated if he was utilizing LolCow LLC. She would have to pierce the corporate veil to get to him personally. The LLC would be responsible if what she's saying is true. And if it's true, the LLC should be the one sued, not Joshua Moon. So you've got a contradiction going on throughout this whole thing. Okay. Published an article on kiwifarms.net which included the full legal name and portrait of the plaintiff. Thank goodness the plaintiff went ahead and gave us their full legal name. The article also included links to videos created on YouTube by a New York resident named Andrew Carlson. All right. The video links included the full legal name and portrait of the plaintiff. The article was published in Eastern Standard Time. The article did not bear a timestamp. Since March 14, 2017, the article is live and accessible 24 hours a day. That sounds like an advertisement. Live and accessible 24 hours a day to an international audience on all different time zones, except in countries that censor American websites. So wherever your website can be found. More specifically, the United States of America. That's the footnote. In the aforementioned published article, the plaintiff was ridiculed for 1, associating with Jewish religion and culture. 2, associating and marrying a formerly incarcerated person. 3, allegedly committing adultery. Why is allegedly in parentheses? Why wouldn't you just put allegedly out of parentheses? What are you doing? Gojirify, sorry, a while back said, who doesn't have a gout fetish? Am I right? Oh, that's filthy. And the orange, you never look at Mountain Dew the same after gout, right? The orange cow says, get ready to read the time zone thing a lot. Okay. Yeah, I see Kiwi Farms in the chat. How's it going, buddy? Welcome to the stream. Hopefully you don't get sued for being on a stream in the chat. So, allegedly committing adultery, having a stalker, why is that in quotes, and allegedly being married more than 2 times. Defendant Moon also used the plaintiff's legal name for articles he published on kiwifarms.net, which is, you know, if you're posting an article about someone, you typically would use their name. CK, shill the merch, Nick. I will after the we'll do it between these 2 documents. How's that? For articles he published on kiwifarms.net on April 2nd, 2017, July 6th, 2017, July 7th, 2017, July 13th, 2017, for an international audience on all different time zones, except in countries that censor American network websites. Why would you footnote in that? There is no timestamp available for any of the articles after the expiration of his business license. Joshua Moon published articles, on kiwifarms.net using the plaintiff's name on June 22nd, 2018, August 24th, 2018, December 12th, 2018, December 14th, 2018 for an international audience on all different time zones, except in countries that censor American websites. There is no timestamp available for any of the articles. That doesn't make any sense. At no time before the publication of any of the articles bearing the plaintiff's name and portrait did LolCow LLC or Joshua Moon ask permission from the plaintiff to use her name or portrait for his business. On April 2nd, 2017, the plaintiff discovered the March 14th article. Plaintiff sent an email letter on April 2nd to Joshua Moon to cease and desist from publishing content using her legal name and portrait. Well, why didn't you do it? Why didn't you do it? Plaintiff's Cot also demanded the removal of all content bearing her legal name and photos to be removed from kiwifarms.net. Defendant Moon responded to the email within minutes using an administrative email from LolCow LLC. In the email, he confirmed that he was the person behind the keyboard typing as an administrator of LolCow LLC. 2, that his business was in existence. 3, he owned and operated the business LolCow LLC and its website kiwifarms.net. 4, he was registered by an agent established in the state of Florida. I don't think that's what they meant. 5, that he knew the difference between libel and slander. 6, that he operates under a username called Null, Doxed, and 7, that he refused to remove any article, content, name, or photo on kiwifarms.net relating to the plaintiff. Dun, dun, dun. At no time since April 2nd has the plaintiff ever indicated to Lolcow LLC or Joshua Moon, operator of kiwifarms.net, that it had her permission to use her name, likeness, or portrait for Lolcow LLC. Defendant Joshua Moon has used the articles published on kiwifarms.net about the plaintiff for his own personal gain. This is a point where we pause and remind the plaintiff that people do this all the time. It's called the news. It's called magazines. It's called blogs. It's called blogs. Anybody, Facebook, Twitter, whenever you monetized YouTube videos, monetized Gab accounts, Minds accounts, anytime you talk about someone, you might use their name, especially in a news story. Unless maybe they're a minor. Maybe. If they're a minor, you don't. It doesn't matter if you use someone's name, as long as the articles are true or reasonably believed to be true. Because the news does this all the time. You don't have to be a public figure to be newsworthy. Keck7Go says, Watercast and the Tau Empire would benefit from your skills, Kevasa, if only you would see the truth that is the greater good. No. No. I reject the greater good. Blas is correct in my opinion. Yes. Thank you. Defendant Joshua Moon has used the articles for his own personal gain. Defendant Moon seeks notoriety. Yes, seek the notoriety, Josh. And monetary gain from Lolcow LLC. He takes in money and donations for his business, Lolcow LLC. He uses articles to keep his forum relevant to his subscribers and followers on kiwifarms.net and the YouTube. Defendant Moon has published in writing that his website, kiwifarms.net, is seen by thousands and receives millions of hits a day. He has 1,000s of subscribers on YouTube. 1,000s of them. On July 7th, 2017, Defendant Moon also published on Kiwi Farms a headshot photo. Oh, is this person dead? Of the plaintiff falling on the floor outside of a boxing ring. The picture was clear enough to ascertain that the cropped head on a cartoon body was the plaintiff. The photo was published for an international audience in all localities around the world and in all time zones except where American websites are censored. There's no timestamp. That's funny to me. Yeah, Cave, we're going to get to section 230. We're going to get to there. Oh my goodness. None of the information in any of the articles on kiwifarms.net referencing Plaintiff Scott is of legitimate concern to the public. Lady, is it true? All you had to say was it was false. That's what you have to say. None of the information in any of the articles is privileged. Okay, if it's not privileged, then it can definitely be published. The Plaintiff Scott is not a person holding public office. Doesn't matter. Doesn't matter. Oh my goodness. Is there a crime here anywhere? No. Invasion of privacy. Publication of private facts. Full Defendant Moon. In March 14th, 2017. Article on kiwifarms.net, Defendant Moon published an announcement of the plaintiff's marriage to her legal spouse, husband. Footnote. Although Plaintiff Scott did not legally marry her current spouse until 2 weeks after the publication of the article, Plaintiff Scott was deemed married by religious customs protected by her First Amendment rights. which I'm not sure why we're talking about her First Amendment rights. Plaintiff Scott was deemed married. Oh, wait, yeah. Third-party private citizens of the United States had knowledge of this religious custom, and this became the source of announcing Plaintiff Scott and her husband as married. Okay. The article published links to defamatory footnote. A newspaper in California used false allegations made by a third party as its source of information. Ooh, that's who you should sue then. Newspaper articles and information about her spouse's legal problems and incarceration. Footnote. Plaintiff's spouse was incarcerated under probable cause. So he's arrested. Plaintiff's spouse was defamed in the Napa Valley Register in the state of California. He was never convicted by trial, but opted for a plea bargain under duress for violation of his Eighth Amendment rights. Okay. Let me help you out. If you're incarcerated under probable cause because you pled guilty to the crime, then you were incarcerated because you pled guilty to the crime. Pleading guilty. Now, we can have a separate discussion about the validity of pleas and the abuse of pleas in our legal system, because they are absolutely abhorrently abused, and lots of innocent people go to jail on bad pleas. Absolutely. But he did plea. So what are you going to do there? The intent of her announcing her marriage to her spouse was done with the intent to embarrass and shame the plaintiff. Why? Why is it embarrassing and shameful? It is not of legitimate concern to the public who the plaintiff chooses to marry. I'm sorry. Marriage licenses are public. They're often announced in various local newspapers when they occur. Of course they're concerned to the public. So is your divorce. So are all of your divorces. How many are there now? A dozen? 30? 40? Kiwi Farms, can you how many divorces are there? Oh my goodness. Who the plaintiff marries is not privileged information. That is correct. There is a true statement. It is not privileged information who a plaintiff marries. Plaintiff Scott finds the international publication of her marital associations as highly objectionable. Wait, are they married in the state of California? Someone want to tell me where they were married? Oh, it says where did they get married? The article published by KiwiFarms.net included details regarding a New York resident who the plaintiff had obtained a protective order against on February 19th, although the protective order was issued by a circuit court in Virginia. Well then, okay, so if she got married in Virginia, then she should be mad at the state of Virginia for publishing her marriage details. Although the protective order was issued by a circuit court in Virginia, the protective order was not intended to be a public document. Not how it works. It's a public court. It means it's a public document. It is a matter of public concern when someone has a restraining order against them, because that person can't have a gun. They can't go to certain places, and you might need to know that. So it is actually a matter of public concern. Absolutely. Okay. As of the date of publication of the article, 10, published by KiwiFarms.net on March 14th, the protective order and knowledge that the plaintiff was being stalked was private information. The plaintiff's legal problems with New York resident Andrew Carlson is not of legitimate concern to the public. No, when you take it to the court, it becomes legitimate concern immediately. Information about plaintiff Scott's legal problems with New York resident Andrew Carlson is not privileged. Again, correct. She's getting like 1 out of 1 out of 8 sentences in every paragraph. Plaintiff Scott finds the international publication of her legal problems with New York resident Andrew Carlson as highly offensive and objectionable. Okay. That's not a legal issue. The article published on March 14th by LawCal LLC has been published with the intent to publish private information that others would see as embarrassing and to lower the opinion of the plaintiff in the eyes of others. How do you know? How do you know that? The publication and inclusion of private details about the plaintiff's legal spouse was added with the intent to embarrass and shame the plaintiff. I don't think you can know that either. The article ends with the conclusion that the plaintiff's spouse is an angry guy who is married to this woman, 11. The woman being referenced to Melinda Leigh Scott. Your full legal name? No, you did it. No! Melinda, wait a minute. The publication and inclusion of private details about her legal problems with Andrew Carlson was written with the intent of embarrassing the plaintiff for having a man stalking her. How embarrassing it is to have someone stalking you. It's not embarrassing. I don't think. It depends, I guess, on why he's stalking you. The article ends at the conclusion that, quote, to recap, we have an obsessive, terrifying neckbeard who stalks the previous two, footnote, the previous two to include plaintiff as a woman who changes husbands like she changes panties. Oh, okay. So how do we have an obsessive, terrifying neckbeard who stalks the previous two and documents it all for our viewing pleasure. No timestamp is available. Plaintiff Scott sees the public disclosure of her legal problems with New York resident Andrew Carlson as highly offensive and highly objectionable. You already said that. And the legal problems of your husband. Okay. Yep. There you go. Doug Confrere says, Melinda, no! No! Oh, I don't know anything about this person. I don't know anything about her at all. Gosh. Like, why is this guy stalking her? Okay, defamation. Let's see. Let's see how this one goes. Defendant Joshua Moon uses a profile on KiwiFarms.net named Null. He has positively identified himself in email as Null. The choice of photo for the user Null is the resemblance of a canine with fangs. Okay, he loved her. He loved her. He's over her now. Oh, canine with fangs. Defendant Joshua Moon, using his own personal profile, Null, has published publicly statements that the plaintiff is. I'm gonna have to censor some of these, Josh. You've got some nasty language in them. The plaintiff is 1, the dumbest person probably ever. Footnote. Published by Null profile on March 14th. No timestamp available. 2, really effing stupid. Same thing. Same footnote. 3, a moron. Same footnote. 4, writes like she uses Crayola magic marker. That's another reference to demean the intelligence of the plaintiff. And 5, a slut whore. Statement made by Null profile, published in an article published December 12th. And 6, had like a dozen husbands by age 30. Statement made by Null profile on an article published December 12th. There's no timestamp available on KiwiFarms.net. Each of these statements in bullets 1 through 6 have been. That's enough for a revolver, lady. Be careful. have been made for an international audience and can be accessed 24 hours a day, anywhere in the world by any person in any locality, except in countries where internet access to American websites is centered. No, you should hire her to write ads for Kiwi Farms. You can get the information anywhere, at any time, in any country and locality, except in countries where American internet is censored. The statements were made with the intent of casting the plaintiff in a negative light and to harm her reputation anywhere in the world the comments could take effect. This is a bad case. This is a bad case. With defamation, especially when you're trying to give the court jurisdiction and let the court know that you're in the proper court, right? Because court needs to have jurisdiction over the matter as well, and to do that, you have to show that the defamation is impacting you in a specific place. The more widespread and general the defamation, the less likely it is that it's targeted to a specific spot. So this is weird. She should just allege that it's causing damage to her in Virginia. That's what you want. You want the damage to be localized to Virginia. Not like, oh, it's everywhere. Statements were made with the intent of casting the plaintiff in a negative light and to harm her reputation anywhere in the world. Comments could take effect. The intent of his defamation was also to lower the opinion of her in the eyes of others. She's trying to cite legal standards for defamation here. That's what she's trying to go to. She's not doing it well, of course. Hire an attorney. Hire an attorney if you want to do this. If you're going to do it well. None of Defendant Moon's statements regarding the plaintiff's intelligence, marital relationships, or alleged sexual encounters are of legitimate public interest to the public. None of the information published about Plaintiff Scott is privileged. All of the defamatory statements by Defendant Moon and Plaintiff Scott are highly offensive to her. Notice what she doesn't say. She doesn't say they're false. She doesn't say they're false. Clay, the tea is because I was falling asleep earlier. So I'm hoping the caffeine kicks in just a second. You gotta say it's false, though, lady. If it's not false, it's not defamatory. What do we got? Oh, yeah, we're good for a second. Second little shot of the Glenlivet. Glenlivet grows on you, man. VG says, any attorney who takes this kind of case is a crook. Yes, that's the point. Go hire an attorney because they'll hopefully tell you no. Just say, no. No. Malice. You don't need to prove malice. You're not a public figure. Pub Test says, this document is a glowing reference for Kiwi Farms. I must visit more often now. Oh. Malice. Defendant Joshua Moon defamed the plaintiff and invaded the privacy of the plaintiff with willful malice. Okay, here's a pro tip for you if you're in the complaint writing department. Iqbal versus Twombly. Iqbal versus Ashcroft. Twombly versus Bell? Twombly versus Bell? Doesn't matter. It's currently the Iqbal standard. Pleadings cannot contain conclusory allegations. Okay? So you can't, or if they do, the court is directed to ignore a conclusory allegation, a legal conclusion. It's only supposed to take on factual matters, factual allegations, right? So, defendant Joshua Moon defamed the plaintiff. Boom. Legal conclusion. Out. And invaded the privacy of the plaintiff with willful malice. 2 legal conclusions, 1 statement. Out. The court can't even read it. Defendant Moon acted with intent to embarrass, humiliate, and vilify the plaintiff. That's almost there, but that's a legal conclusion. You would have to say, on information and belief, Defendant Moon, plaintiff asserts that Defendant Moon acted with the intent to embarrass, humiliate, and vilify the plaintiff, and that won't be a factual statement. You got to show the intent. You got to show it with alleged facts. Merck says, what determines your status as a public figure? Well, there's a couple different things. If you're a government employee, you are a public figure. But let's be clear that the public figure doctrine, as it applies to most government employees, is that it produces a reduced standard for defamation, or a heightened standard, I should say, for proving defamation. More lax standard for the person who might be doing the defamation, if that makes sense. Higher standard for defamation if it's a public figure and the criticism is in regards to the public figure's public duty, right? So a police officer who shoves a white person, for example, you can say that police officer is racist and hates white people, even if it's not true necessarily. But you can criticize them because that was in the course of their duty. Does that make sense? If they're acting as a police officer, what you can't do is start defaming them about their private life and get the heightened standard, because that's not in the course of their public persona or public duty. If it's about their private life, they're given the same protection as you or I. But a government worker is pretty much a public figure, especially an elected one, often an appointed one. Now, like drone government workers who are hired and are just staff, not as much unless their job has a public sort of face to it. It kind of depends. Other than that, what determines your status as a public figure is the matter a public concern? Are you a news member? Or are you in the news? For example, Stormy Daniels, when she sued Donald Trump, Donald Trump is obviously a public figure. However, she was suing him for defamation against her. The court determined that by entering into basically a public media argument with Donald Trump prior to him making the statements, by going on Twitter, by going on news stories, by talking about Trump during an election year very publicly, when all of this was going on, it said that she basically made herself into a public figure for a matter of public concern. So if nothing else, Stormy Daniels was a limited public figure. If she was a full public figure, well, I guess she is full figured, right? Is that a joke? I don't know. Dan says, Josh is in chat. Get him on, bud. Also, Melinda, no! I don't know. Josh, did you want to come on the show? I mean, I don't have any problem with that. But, you know how it goes. Oh, I didn't do it. I didn't show what the... Hold on. I failed in my duties. To Josh. I was supposed to pull up the vicious canine in the avatar with all the fangs. With all of the fangs. Let me hold on, here we go. I'll get it ready. We're doing it live. All right, let me just go ahead and add an image here. Look at all the fangs. Look at the canine's fangs. No. There you go. There you go. All right. All right. There's the fangs. There's the fangs. All right. Where were we? Okay, back to malice. Sorry. I gotta. You gotta hang out and marinate in the stupidity, right? Real Lady Raggeds, thanks for joining. I'm not talking about that postal employee right now. Not right now. Okay. All right, let's get back to this. Defendant Moon acted with intent to embarrass, humiliate, and vilify the plaintiff. Lolcow LLC publishes that their mission is to, quote, milk for amusement the stories and people they post about. Josh, how many people have you milked? I better answer you. Yeah, we can talk about the stupid postal employee who sent back our packages today without scanning them like a dummy. We can do that. Whoever it was who did it, I don't know their name, so I can't actually do it. But yes, that would be a public employee in the course of their public duties who we would criticize very much. Very much a public figure. Okay. Thousands. Kiwi Farms has milked thousands of people. That's disgusting. What was that line from Meet the Parents? I have nipples, Greg. You gonna milk me? Milk for amusement, the stories and people they post about in emails and online. Joshua Moon has used vulgar language toward the plaintiff. He has emailed and published statements from his own user profile, null profile with canine photo, labeling the plaintiff as a effing moron, effing banshee, and dumb female dog. I think he's hitting on you with the profile picture, and the dumbest person possibly ever. Defendant Mr. Moon has spoken about the plaintiff. Are you Moon Man? Has spoken about the plaintiff online in a derogatory manner to cast the plaintiff in a negative light in front of an international audience in every locality around the world. The publicized and uncensored. 21. Since April 2nd, Defendant Moon refused to eliminate any anti-Semitic or misogynistic libel by any user on his site. Is it libel? Like, can you libel a race? No, Tillip, they did not send back the gift you got for me. I got that gift. I've been meaning to thank you. I keep leaving it upstairs. I got that. Can you libel a race? Well, I don't know. Publicized and uncensored articles on kiwifarms.net. Ooh, sounds sexy. Made about the plaintiff are misogynistic and anti-Semitic, seeking to vilify the plaintiff for having matriarchal elements in her family. Matriarchal elements in her family orientation, as well as for identifying with Jewish culture and religion. By choosing not to delete the content on his pages, Defendant Moon has willfully reinforced and promoted malicious behavior from his users. Wrong. Wrong. Invasion of privacy. Appropriation. For Massachusetts, Defendant Brian Zeiger. Defendant Brian Zeiger is a resident of Massachusetts. A Brian Zeiger of 116 Lafayette Street is listed as being arrested in the Salem police reports on February 11th, 2018. 116 Lafayette Street matches the address listed for the service in Montserrat versus Zeiger. Oh, wait a minute. Did you just use a publicly published document with an address on it? How dare the United States government through the public access to court records. How dare they dox Brian Zeiger? Don't say blood libel on stream or they will suicide you? Oh no. Oh no. Let's see. And owns 23. As of the date of this pleading, Brian Zeiger lists himself as the owner of Encyclopedia Dramatica on LinkedIn. Montserrat versus Zeiger, a case filed in Massachusetts, also verifies that Brian Zeiger was the owner of ED. He owned his ED at the time of publication of the article referencing plaintiff Scott on July 13th. A wiki website called Encyclopedia Dramatica. See Massachusetts case Montserrat versus Zeiger, civil action number whatever. The website has been established since December 9th, 2004. And I got beef with Encyclopedia Dramatica and takes in money through the form of donations and advertising. On July 13th, 2017, defendant Brian Zeiger published an article using the plaintiff's picture. The name used to identify the plaintiff is Melinda. Operating under patriarchal assumptions, the article misidentifies the plaintiff as having absorbed the former last name of her legal spouse, husband. Submit to the patriarchy, all you oppressed women who take on last names. Eat the patriarchy, Lady Rackets. Carlos Miguel Ugalde, have you read Tonka's contract yet to attest to your affirmations on the Ralph retort? What? Tonka's contract? I haven't seen Tonka's contract anywhere. Has Tonka released the contract? Or are you asking if I've gotten it from Valor yet? I don't know if Valor's going to give me the contract. I have not seen it. Yeah, Ryan English. Apparently matriarchal Jews can absorb last names and add to their power. That's what I'm getting from this document. Can anyone confirm? Is that what Ruth Bader Ginsburg is doing? Is she just this whole time, I thought Ginsburg was drinking the blood of infants and having foreskin stem cells injected into her brain to keep her alive. I was wrong. Ginsburg is busy chain marrying men and absorbing the life force from their last name through her wicked Jewish powers. That's why Scalia's dead. That's why Scalia is dead. Oh my gosh. The forum does not provide a timestamp for the article. What's these timestamps? Just the date is fine. The date is fine. The article is available 24 hours a day for an international audience in any time zones except where American websites are banned by censorship. The article is labeled as an article which is, quote, part of a series on Jews. Okay. Siren Jag, I saw her latest portrait. It looks very accurate. Very accurate. Oh. At no time since the publication of the article has Plaintiff Scott ever indicated that Encyclopedia Dramatica has her permission to use the plaintiff's portrait or name for Encyclopedia Dramatica. On December 27th, the plaintiff sent an email to ED demanding the removal of the content bearing her name and portrait. On December 28th, plaintiff emailed defendant Zeiger to remove the content. Defendant Zeiger denied in the email that he was affiliated with the ED website. That's because my understanding is at that point he no longer was. Defendant Zeiger has used the plaintiff's portrait and name for his own personal gain. Encyclopedia Dramatica makes money from advertising and donations. Good on them. Yeah, speaking, brief pause for Encyclopedia Dramatica ad money. You scumbags. When I first started this YouTube channel, my first videos that were made that ended up being monetized were, of course, on the Maddox versus Dick Masterson lawsuit. That was the first thing I covered. You can go, I have the series playlist still listed, I think prominently on the channel page. It's one of the top playlists that's available. Anyway. So in Maddox's stupid lawsuit, he references an Encyclopedia Dramatica article, and there's a link to it. And I clicked on it, and my computer instantly got like 12 viruses and shut down in the middle of recording. And I had no idea what I was doing at the time. I was using literally the Microsoft Camera app to record videos because I didn't even know OBS existed. I didn't even intend to start a YouTube channel at the time. I was just like, I just want to record this thing for the Facebook group and I'll just throw it up on YouTube. And it got completely shut down by viruses. Thank you very much for that, you scumbags in Encyclopedia Dramatica. Aiden, hey, what's up, Aiden? Welcome to the chat. Okay. Invasion of privacy, false light. Always use uBlock when visiting ED. Yeah, I know. Believe me, I know. I mean, never mind that I did it again the next night. Shh. Within the same article, published July 13th, this is a footnote, on Encyclopedia Dramatica, defendant Zeiger publishes false statements about the plaintiff, attributing sexual acts to the plaintiff which are untrue. Oh, this goes... this goes in your defamation claim. Defendant Zeiger made the following untrue statements about attributing sexual allegations involving the plaintiff. That the plaintiff committed sexual acts with an unnamed former landlord. That the plaintiff is a former prostitute. And that she sucked the peen for rent. The article claims that the information was received by the plaintiff's stalker. The other false statement published in the article, according to the plaintiff's stalker, is that the plaintiff has 4 baby daddies. Footnote. Baby daddies is a modern secular term to mean children conceived through sexual acts outside of a legal marriage license. Nope. No, it's meant to mean the parent, the dad of children conceived through sexual acts outside of a legal marriage license. Oh. I do have a certificate in computer security. I should know about script blocking. Now, to be fair, my cybersecurity certificate is a cybersecurity law certificate. I wouldn't purport to know anything about the mechanics of doing it. All right. Let's see. The article also falsely states that the plaintiff has had 9 husbands. The statements are highly offensive to plaintiff Scott. Defendant Zeiger also published within the same article on July 13th written statement saying that the plaintiff was a horny Jewess with loose morals and incestuous. 30. The article reads that an alleged relationship with a cousin makes the plaintiff incestuous. Although marriage between cousins is legal in many states and not prohibited by Judaism, however, the use of the term incestuous in context of the article is aimed at casting the plaintiff in a negative light in front of a secular international audience. I don't know, maybe. But it's also maybe just an accurate description of the relationship. So there you go. These statements were published with, with the intent of casting the plaintiff in a negative light. The statements are highly offensive to plaintiff Scott. These statements are not true. Wait. Oh, no, Melinda. Why? Guys, they're not true in quotes because plaintiff Scott does not subscribe to the same secular and or religious beliefs that spawned the terms. No. 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 For those of you following at home, that means that the allegations are true. She's just disagreeing on that pesky terminology. The defendant's use of baby daddy is an attempt to cast shame on the plaintiff for one, having matriarchal elements in her family. Wait, what? What does that have to do with anything? 2, for not having an abortion. That's rude. And or 3, for not using birth control. So apparently ED is like a trad Christian blog now. ED is Matt Walsh. Since statistically, it is reported that the average American female under the age of 40 has had 8 sexual partners. It can be inferred that defendant Zeiger is not remarking on the plaintiff's relationship choices, but rather that she has borne children as a result of her relationships with the opposite gender. Okay. I can't stop laughing. All of defendant Zeiger's terms listed in 9 and 20 used to label the plaintiff were to cast shame on the plaintiff. I think it must be XIX. I don't know. Used to label the plaintiff or to cast shame on the plaintiff in front of an international audience in all localities around the world. The intent was also to lower the opinion of her in the eyes of others. Since it is commonly known that it is a cultural custom for people in the United States to use social media. Okay, so the internet to investigate people for employment is now a cultural norm. White Devil. I can't change the chat from top to live because Streamlabs OBS doesn't allow you to interact with a web page yet. It's a known problem and issue. I can't do it. If I could, I would immediately. If I could, I would do it immediately. Okay, Bluebird says, if you were my cousin, I'd cuddle with you. No homo. Aw, thanks, buddy. Thanks. I appreciate that. I like the Spike Man says, nothing wrong with cousin cuddling. I mean, I guess if you have matriarchal elements in your family, there's not. Oh my goodness. All right. It is commonly known that it's a cultural custom for people in the United States to use social media and the internet to investigate people for employment, housing, and social reasons. It can be reasonably assumed that publication about a person carries the intent of harming them within their local community. Not how defamation works, or false light, or any of this stuff. And with anyone else who will believe untrue statements and negative statements. The statements published by Zeiger are highly offensive to Plaintiff Scott. Well, if the statements are offensive and they're true, maybe your life is offensive to you. Invasion of privacy. Invasion of privacy. In the article published July 13th, defendant Zeiger claims that he received information about the plaintiff from the plaintiff's stalker. The article labels the plaintiff as the object of his obsession. 32. His being a reference to the aforementioned stalker. Mysterious Senor Hilter, not Hitler, Hilter, says someone was paid to write this. Actually, no, I think this person is writing this document pro se. So without legal representation. I believe she wrote it herself. Zeiger, yeah. Zeiger also published hyperlinks to the March 14th article from kiwifarms.net. The intent of the hyperlink in mentioning that plaintiff has a man stalking her is with the intent to embarrass the plaintiff. Plaintiff Scott sees the disclosure of her legal problems as highly offensive and highly objectionable. Good. Good. Defamation. The published article was discovered by the plaintiff on July 13th. Within said article, defendant Zeiger imputes acts of unchastity to the plaintiff, which are untrue. Now this, she's done a little bit of homework at least. Per se damages in defamation acts can include labels that make a person believe that a woman is unchaste, that they speak to her inchastity or unchaste nature. That's because defamation law stems from common law, and common law started really around 14th century English society and started building out of there into the system that eventually carried over into the United States. The common law, you know, the England running the United States for a while did control the legal system, and that legal system translated when we rebelled against them. We borrowed pretty much all of English common law. We needed a basis for all of this stuff rather than starting from scratch. So English common law is our system, and because defamation is such an old action, I don't know exactly where it came up. I don't know exactly where, but I do talk about it briefly, that defamation basically came up as a solution to duels. You're still talking like the 17th century is where you started getting defamation actions to show up. You've got different ideas about women than we have now, right? And so that literally the chastity of a woman is a long-sighted thing. But however, isn't this person talking about the patriarchy just a little bit ago? She should know that chastity of a woman isn't relevant anymore. Not at all. Okay, Gravedigger says, I'm new. Can you explain the daddy no joke? And then I Like the Spike Man replies and says, at Gravedigger, Google Tonka Saw Father. Yeah, that'll get you there. That'll get you there. Jay knows the way. Hey, can you talk about Ralph's case? Maybe. And how he is not in jail for all the drinking he's doing. He's not in jail for the drinking he's doing because a prohibition on alcohol is not part of his probation. That's how. It's really simple. I don't think... I mean, he's drinking in public. If it was a part of his probation, he'd have a real issue. But no, he's apparently it's not part of his probation at all. I could probably look it up, but I'm not going to do it right now. Okay. So that's why she's bringing up the imputed acts of unchastity. The article falsely accused the plaintiff of formerly being a prostitute and sucking penises for rent. There is no timestamp available on the article. The statements were written for an international audience in all localities around the world, in all time zones, except where American websites are censored, since it is commonly known that it is a cultural custom. She's just adding these boilerplate phrases that she came up with. Commonly known that it is a cultural custom for people in the United States to use social media and the internet to investigate people for employment, housing, and social reasons. It can be reasonably assumed that publication about a person carries the intent of harming them within their local community and with anyone else who will believe the libel. Libelous statements chosen by Zeiger are highly offensive to plaintiff Scott. And Merck says, all that booze and none of it came from Tennessee. For shame, Nick. I'm still chipping away at my haul. Also, super chat, drink. Thanks, buddy. I will. No, none of it came from Tennessee. Actually, no, that's not quite true. This bottle was purchased in Tennessee. This Glenlivet Nadura was purchased in Nashville. I was unable to bring home any peg leg porker. I was really depressed about that, actually. But there were only 2 bottles left at the liquor store. One I gave to Ethan Ralph, and the other one I gave to Doug TeNapel. So, I couldn't bring home any peg leg porker. Very sad. Very sad. And then Harkanu donated $10. He didn't have a whatchamacallit, a comment with that, but thank you very much. I appreciate it. And Nix Hex says, how does Scott know so much surface level legal phraseology, but makes nothing but wrong claims? Is she just hoping the judge will side with her for reasons? I mean, you can learn a bunch of legal phraseology by just like Googling defamation, and it'll talk about, I mean, if you Google defamation and read a couple articles, you'll find the accusations of unchastity towards a woman. You'll find that phrase specifically. So, I mean, that's what she's doing, I'm guessing. Tillip, I'm going to shill the shirts between these two, whatchamacallit, things. Oh my gosh, I don't have the Stream Me chat pulled up. What a jackhole I am. What a jackhole I am. Let me get this pulled up on my screen so I can follow along. Okay. Here we go. Stream Me, I see you there, guys. I apologize for not having the chat up earlier. What a scumbag I am. And I am forever apologetic and humbled by your presence. Okay, I like the Spike Man says, continue to wreck this kite. Glad to donate to you tonight. You doing any less fact-filled streams? Would love to see you. Good off, man. I don't know. Less fact-filled streams. I'm not sure what that means. We'll see. James Colley says, what are your thoughts on tongue-buttering turtle caves and his cereal soup? Tongue-buttering turtle caves? What? Oh my gosh. Is cereal soup? No. Cereal's not soup. Cereal's cereal and delicious. All right. I don't even want to talk about tongue-buttering turtle caves. I mean, I kind of do, but I don't at the same time. That's just horrifying. That's a horrifying remark. Harkanu again with a donation. Thank you so much. And then 1488 Forever says, only get to tune in and then now and then. What happened to the window? What window? What window? What window? If you don't have to drop another super chat, just tag me and follow up on that question and tell me what window you're talking about. In the meanwhile, I'm going to get back to the defamation thing. Catch you later, Spike Man. I love the Spike. I like the Spike Man. See you later, buddy. Okay. Sorry. Where are we? It is commonly known that it is a cultural custom for people in the U.S. to use social media and the internet to investigate people for employment, housing, and social reasons. It can be reasonably assumed that publication about a person carries the intent of harming them within their local community and with anyone else who will believe the libel. The libelous statements chosen by Zeiger are highly offensive to plaintiff Scott. I mean, publishing anything doesn't mean it's for the purpose of being harmful. So that's weird. That's weird. Oh, the window behind me. Yes, sorry. We moved to a different house. Thank you for following up on that. No, I'm now in a vault, a literal vault in my new home. The window behind me is gone. Sorry. Okay, in fairness, in the Hambly versus Loader lawsuit, Loader is alleged to have punched a window at the Tin Roof Bar. Okay, so he's alleged to have punched that while staring either intently or homosexually at Hambly. I'm not quite sure which one it is, and that is part of the assault claim. So I wasn't sure if he was talking about that window, or if there was another window involved in a lawsuit that I was missing, or if there was like a window I had pulled up on stream at some point. That's in fairness to me, but no, the window behind me, the physical window that went to the outside world, is long gone. I'm now locked in the basement of Lady Rackets' home. So there you go. And I can show you guys the vault in a little bit if you want. Robert Muldoon says, Super Chat's got you a new house. No, not quite. But they do help very much, and I appreciate every single one of them. Jira1 says, pee is stored in the balls. And then 1488 Forever says, blink twice if Mossad is holding you captive. I don't know if that's ambiguous enough. Okay, malice. Defendant Zeiger has acted with intentional malice. The subtle way, the subtitle for the picture that includes the plaintiff states that the plaintiff is a, quote, Jew on her way to Auschwitz, which, 33, a reference to the historically famous Nazi concentration death camp. Oh, that Auschwitz. Oh my goodness. Thank you for clarifying that that's what he meant by Auschwitz. MB says, you leave Matt Walsh alone, good sir. Can't take it. This lady's a genius. The intent is anti-Semitic. The statement can also be construed as a death threat. Nope. Or a threat of conspiracy to murder the plaintiff because she identifies with the Jewish religion and culture. I mean, not really. Auschwitz has been shut down for 70 years. Are they going to fire it back up just for you? Encyclopedia Dramatica is publicly and commonly known as a less than ethical wiki website that picks targets and slanders them in writing. He libels them in writing. Can't. Oh, that Auschwitz. Target audience. What does this have to do with anything? Defendant Joshua Moon controls and operates his computer from Florida. Defendant Zeiger operated his computer from Massachusetts. The computer exchange software and internet social media that they are using are Google, YouTube, and independent website forums. Each of these software and publishing sites are maintained for international audience in all localities around the world. The intent of both defendants is to reach as many people as possible. With an international approach, the defendants are aiming to bring the largest scope of harm possible to the reputation of their targets. Since it is, I talked about this earlier, this is not the route you want to go in a defamation case. You want to show that they're harming you in a specific spot where you're bringing the suit. That's where the harm needs to be done so that the court has jurisdiction over you. They're kind of harming you equally everywhere. I mean, they might have something, but you really want the locus of the harm to be where you are suing. Okay. The DCV Titan says, oh, that Auschwitz. I thought she was talking about the rundown cat daycare. But then I remembered that is Meowschwitz. James Colley says, those are stream lore questions asked on Lords of the Night, hosted by Ranting Monkey, Scribelight, and Satsu 2 Cents, Monday to Saturday, 8 p.m. to 10 CST. Well, there you go. There you go. Oh. All right. Google, YouTube, and independent website forums. Each of these software and publishing sites are maintained for an international audience in localities all around the world. The intent of both defendants is to reach as many people as possible. Dun, dun, dun. It's the internet. Try and reach as many people as you can before you die. With an international approach, the defendants are aiming to bring the largest scope of harm possible to the reputation of their targets. Since it is commonly known that it is a cultural custom for people in the United States to use social media and the internet to investigate people for employment, housing, and social reasons, it can be reasonably assumed that publication about a person carries the intent of harming them within their local communities and with anyone else who will believe the information and statements. Nope. No, it doesn't have... That doesn't logically follow that you're trying to harm someone by talking about them. Now, maybe you mean by talking about them negatively, but that's not what you said. That's not what you said. Oh my goodness. Length of time. As the filing of this pleading, the March 14th article published by defendant Joshua Moon has been published for more than 600 days. The July 13th article published by Brian Zeiger has been published for more than 450 days. Plaintiff discovered the article published by defendant Moon on April 2nd, discovered all other articles on Kiwi Farms within 6 months of their publication. So she became a regular. Josh, you did it. You did it, Moon. You converted one. You got a regular viewer. That's your master plan. Now to lolcow everyone on the planet. one person at a time. Plaintiff discovered the July 13th article written by defendant Zeiger on July 13th, 2018. That's a year. That's a year. Oh, emotional distress due to invasion of privacy and defamation. Jason Benaim says, in what time zone is Auschwitz? I think it's in all time zones except the ones censored by the United States. Due to their invasion of the plaintiff's privacy, both defendants have caused the plaintiff substantial emotional distress and grief, more than ordinary everyday upset. Defendant Moon has caused the plaintiff substantial emotional distress since the plaintiff's discovery of the March 14th article. Okay, here's the first problem with your claim. You only received emotional distress after you discovered the article. Intentional infliction of emotional distress requires an act so outside of normative behavior as to be shocking and offensive to a reasonable viewer. Okay? A reasonable observer. Not viewer. Too many YouTube terms. A reasonable observer. So, to intentionally inflict emotional distress to someone, you have to do an act to them. This claim's gonna... Even if everything this lady says is true and actionable, this isn't, because you can't just like do something over here and that when they discover it, they're offended. That's not you trying to inflict emotional distress. You inflicting emotional distress would be, you know, putting up nude pictures of them and emailing all of their, students if they're a high school teacher, right? Like that would be intentionally inflicting distress. You're causing an act that causes them to have the attention brought to them. Just going ahead and making a post about it isn't doing anything just because you discover it. Because the test for this is, had she never discovered the page, she would never have been distressed. That's not intentional. It's maybe a negligent infliction of emotional distress claim. She doesn't really distinguish between the two here, but even negligent infliction is really, really hard to prove. Really hard to prove. Joey Jojo Shabadoo over on Stream Me. No, I'm talking about a apparently Jewish woman named Melinda Scott, who has sued Joshua Moon of Kiwi Farms and Brian Zeiger, formerly of Encyclopedia Dramatica. So that's who we're talking about now. Okay. Defendant Zeiger has caused the plaintiff emotional distress since the plaintiff's discovery of the July 13th article. Harmed her reputation for invasion of privacy and defamation. So she's trying to lay out damages. Not very well. The plaintiff's legal name is the name she conducts business with others in her local community on behalf of her minor children. Wait. Let me reread that. I think the whiskey read that sentence and it didn't make sense. The plaintiff's legal name is the name she conducts business with others in her local community on behalf of her minor children. Okay. Her legal name is the name she bears on her bachelor's degree diploma and professional trade certificates. Well, how many does she have? The plaintiff's legal name is the name she uses to Melinda Leigh Scott. She wrote it in the document. Just in case we're unclear on what her legal name is the name she uses to conduct business in her local community as well as business across the nation. The plaintiff has a copyright with her legal name. Okay. I mean, you can't have a copyright with not your legal name. That would be a violation of the copyright statute if you tried to copyright something that with not you. The plaintiff is in the patent process and cannot abruptly change her legal name. Due to the changing your legal name wouldn't remove your copyright, by the way. And changing your legal name wouldn't remove your patent application either. You just have to file the name change document with the court. You could even cite that someone was harassing you with the Patent Trade Board. There's no way they're going to care. The only people who care if you change your name last minute are fight promoters in Tennessee. That's the only people who care if you change your name in the middle of something. Due to the long-standing use of her legal name. Well, wait, I missed a thing. I missed a footnote. Where was it? Oh, at the end of the length of time. At that time, the plaintiff contacted the Anti-Defamation League for assistance in removing the article. Okay. Can you imagine? You're the Anti-Defamation League. Whatever you think about the ADL, just imagine you're the guy at the desk of the ADL, right? Like you're sitting there, I don't know, spinning a menorah on your finger. What did they do at the ADL? I'm not sure. You're there spinning the dreidel, right? Waiting for the phone call to happen. You get the phone call. And a lady's like, someone posted me on Kiwi Farms. Like, it's the ADL. They're combating what they perceive to be anti-Jewish sentiments from like major media outlets, from politicians, from I don't know, kids in MAGA hats at the Lincoln Memorial, wherever they are. Like, they're out there fighting big fish, and then random member of the faith calls up and says, someone posted an article about me because I've been married so much that it's funny. And that I absorb my husband's last names or whatever. Oh my goodness. Siren Jag says, show me on the doll where the forum harmed you. Absolutely. Mysterious Senor Hilter says, the only thing this lawsuit needs is a die null. There you go. Onion Wizard, it's unclear how many times she was married, but according to her, at least one of them was to a cousin. So we're just going to put that out there. Which is not against the beautiful Judaism faith. Let's see. Plaintiff's legal name is the name she uses to conduct business in her local community as well as business across the nation. The plaintiff has a copyright with her legal name. Oh, wait. Yeah. Due to long-standing use of her legal name for business, professional, and social reasons, the plaintiff should not bear the burden of changing her name to deter any harm to reputation. Well, that's true, unless you caused it yourself. Between March 14th and the current date, Defendant Moon has caused harm to the plaintiff's reputation internationally and locally by defamation of the plaintiff, by appropriation and the publication of her private information. The way in which the harm has been caused follows in paragraphs 30 through 33. She's Jewish, but she's using Roman numerals, which I don't understand. Defendant, just use American numerals. Defendant Moon has caused other internet users to hold the plaintiff under criticism and contempt. Other users on KiwiFarms.net have been rallied by Defendant Moon and echoed his defamatory statements. Footnote: the statements that follow are a collective sum of statements in all articles published on Kiwi Farms between March 14th and the date of this pleading. Now, I know she means published about her, but guys, let's just realize that the following collective sum of statements is a summary of all articles on Kiwi Farms between March of 2017 and now. Here we go. By calling the plaintiff, and I have to censor these for the internet because you guys are just too young to hear this naughty language. A dumb effing B word, crazy, stupid, dumb donkey, I guess, dumb B word, vapid B word, dumb, right old B word, loony moron, nuts, and I can't even say this one. Kike. We'll use the like Hawaiian pronunciation. A kike. They have similarly echoed the statements in the KiwiFarms.net published article and falsely accused the plaintiff of having a list of husbands, 9 husbands, had husbands who have disposed of her, goes through so many men in such a short time, a gigantic whore. Is that a Tess Holiday-sized whore? Is on her 9th husband, that she stalked an alleged ex-husband, and that she has had sexual acts with a former unnamed landlord. KiwiFarms.net publications also circulated from its users false statements that the plaintiff, this is the same footnote, sucked penis for rent and had an incestuous relationship with a cousin. Important to note, on that incestuous relationship with a cousin, she didn't disagree with the relationship, only the terminology describing it as incestuous. Merc says, didn't realize we were on the same Discord. Hit me up, BB. Okay. Nixhex says, as a viewer in Echoes, I can confirm that holidays with family consist of nothing but menorah spinning. Thank you. Thank you for that. Thank you. Defendant Moon is also responsible for contributing to the conduct of Defendant Zeiger, who published and hyperlinked borrowed content from Kiwi Farms on Encyclopedia Dramatica. On August 24th, 2018, it became apparent that the articles online published by Kiwi Farms were causing more actual harm to the plaintiff's reputation. When statements were made to her by neighbors demonstrating that the articles written by the defendants brought her under criticism and contempt. I mean, come on. On August 24th, the plaintiff was told by a neighbor that she was a Hebrew pagan. The same neighbor stated that if she didn't like their footnote, in using the pronoun there, the neighbor was referring to a number of apartments that hangs out together on a regular basis. How do apartments hang out together? Are these Google employees that identify as apartments? Is that what's going on? Oh, and by the way, brief side note. Can I get, it's up to you guys, an F or an S for Liz Fong Jones, the Google employee who is now a former Google employee. Liz Fong Jones, 11 short years at Google. You can just F or S that all you want. She is no longer employed. I don't know if I should even say she is no longer employed with Google as of today. Liz, you're still an idiot. There you go. Liz Fong Jones was a major component of the Damore lawsuit, the James Damore lawsuit. So that's the only reason I know the name. Also, right after I did my first Damore video, and it was shared internally at Google, Liz Fong Jones had some comments that I am pretty sure were talking about the video because I named her. I named her in the video. Only because she was named in the lawsuit. Never heard of this person. Don't really care. But yeah. And then, of course, my... Because remember, Kiwi Farms is the cancer. Kiwi Farms is the cancer of the world. And that's where all the doxing goes. Within a day, my bar registration was posted on the internal Google Plus website. And people were discussing filing ethics charges against me for merely reading a public document and calling them idiots. So that's who's at Google. And since I did that, my Google results have been very interesting on the video tab. So there you go. And at the time, I had maybe 3,000 subscribers on YouTube. So that's how butthurt and sensitive these disgusting people, Liz Fong Jones and stuff like that are. That's how pathetic they are. They have they do these petty vindictive actions. All right. Spud Nuck says, Aloha Kike. The Holocaust. The Holocaust is a lie. Not to be confused with the Holocaust. The Holocaust, I think that's what they should have called the eruption of that on the Big Island. The Holocaust. Yes. Not Kula. Wait, what's the Big Island called? Kona. The Kona-caust. That's getting less and less interesting by the minute. What do we got? Oh, Liz Fong Jones. I'll have to read that Liz Fong Jones article later, Josh. Okay, here we go. So where we last left off. Sorry for the tangent and the digression there. I just remembered I saw that Liz Fong was signing off for good, which means somehow she'll be on Twitter even more. But where we last left off, a neighbor of the defendant, plaintiff Melinda Scott, had called her a Hebrew pagan. The same neighbor stated that if she didn't like their treatment of her, she could leave because, quote, no one wanted her there because she goes around suing everyone. Yeah. Melinda, that's not Kiwi Farms' fault. That's your fault. Oh, Maddie P, thanks for the clarification. The Big Island is actually called Hawaii. Kona is on it. Oh my goodness. If you're ever in Kona, make sure you go to a place called Three Little Pigs and eat yourself a very unkosher 1 pound of broiled pork belly. It is delicious. Absolutely delicious. Shout out to Three Little Pigs, even though they're not sponsoring the show and probably wouldn't. Okay. The only way the neighbor had knowledge of many of the lawsuits the plaintiff has been involved in was through the efforts of LolCow LLC, who definitely called up all the neighbors and demanded that they go to the hyperlinks. Owned and published by defendant Joshua Moon. On August 24th, 2018, a neighbor screamed out at the plaintiff information that she had read on Kiwi Farms. At around 6 p.m. Eastern, the neighbor shouted with an earshot of about 20 neighbors and the plaintiff the following statement. Is this her boyfriend who is a pedophile? A pedophile? Oh no! The question was derived from a photo on LolCow LLC falsely portraying the plaintiff's legal spouse as a pedophile. Wait a minute now. Wait a minute now. You didn't mention this before, Melinda. So for those of us joining in just now, Melinda earlier was complaining that her husband had legal troubles and was arrested on false charges and then pled guilty to said false charges. Uh-oh. That means she might actually be married to a convicted pedophile. Like, your neighbors probably want to know that. Oh. Merc, you're heading to Hawaii. Yeah, Three Little Pigs on Kona, buddy. Also, get the, if you get a chance, go to TK's Noodle House and get the ginger lemongrass tea. Really, really good. I could drink that stuff all day. The actions by LolCow LLC to publicly disclose private information and to portray the plaintiff in a negative light for her choice to associate with her legal spouse caused the plaintiff to be brought under criticism and contempt. Guess what's not private information? If your husband is a pedo, it's public, and he's probably on a list. And you maybe should have told everybody that he was on a list. It might be required. I don't know. I'm just saying generally people who get convicted for crimes relating to the sexual exploitation of children end up on the only government list most people like. Full scope of harm of invasion of privacy and defamation. The full scope of damage caused by the egregious nature of all the instances of casting the plaintiff in a negative light, publicizing private information, each act of defamation by Encyclopedia Dramatica can be intrinsically understood and assumed. Same thing with Joshua Moon. Yeah, she's going for per se damages there. All right, back to the scribbling by hand. Request for relief. This is what you're asking from the court. Injunctive relief ordering both defendants to remove all online content which uses the plaintiff's legal name, photos, portraits, or likeness. Nope. Doesn't work that way. You'd have to remove only infringing content. $75,500 in damages for defamation by Joshua Moon. $25,000 for appropriation by Joshua Moon / damages to plaintiff. $125,000 in damages for the publication of private facts by Joshua Moon. $75,500 in damages for the inflicting substantial emotional distress in the plaintiff. That's not a cause of action. The Orange Cow says, what would you say the likelihood is of sites like Kiwi Farms being cited in legit court documents for internet cases due to their archiving policies? Also, name a bottle you like and I'll send it to you. Oh, man. That's a challenge. That's a challenge. It's very possible for websites to be cited in court documents. They are, even if it's just in footnotes for, like if they have a link to something or whatever. That's absolutely possible and likely. So, yeah. I'm hoping that these videos start getting cited in some court documents. That would make my day. As for the bottle that I like, I mean, I like a lot of bottles. I hate to say surprise me. I don't know what to pick. If you don't want to surprise me, okay. Here we go. If you don't want to surprise me, I really want to try the Basil Hayden's rye whiskey, not the Basil Hayden bourbon. I love the bourbon. It's very good. But I'd love to try the Basil Hayden rye. Otherwise, just surprise me. I will appreciate and drink whatever. Okay. Next. 75,500 in damages for substantial emotional distress. 100,000 in damages for defamation against Zeiger. 125,000 in damages for portraying the plaintiff in a false light. 50,000 in damages for appropriation. 25,000 for publication of private information. She's just picking numbers up, making them up here. And 25,000 in damages for inflicting substantial emotional distress. Demand for a jury trial. No. Wait. What? Why would you say no? Guys, I'm at an absolute loss. Why would you say no to a jury trial? This is a case where you definitely would want a jury trial. Because the judge is clearly, clearly going to throw out the case. And did throw out the case. The judge has thrown this case out. Sua sponte. Without any motion or anything, the judge has dismissed this. But juries are full of people, and people acting in groups are stupid. So you pick a jury, absolutely, so you could show how mean Josh is. You go before a judge and say he's mean all day, and the judge doesn't care. Judge doesn't care if someone's mean, but people might care. Of course you pick a jury trial. You almost always... The only time you don't pick a jury trial is when you're a bank. Like... When you're a company that everybody hates, then you pick a bench trial and not a jury trial. That's it. When you have or you're a pedophile or something and you have a legal claim. Although maybe with her husband who may or may not be a pedophile. I guess maybe that's the thought. Jason Benham says the stupidest person possibly ever. I like the Spike Man. Ooh, I thought you said you were leaving. Thanks for hanging around. Says get Nick some Jura. I would drink some Jura. Absolutely. Yeah, I love peated whiskey, peated scotch, Jura, Kilkuchan or whatever. Ardbeg. I'm good with any of them. Well, there you go, guys. That's the complaint against the Kiwi Farms and the Encyclopedia Dramatica. It has been dismissed by the judge. So, I'm not going to read the judge's opinion on it. If you want to see the judge's opinion on it, you got to check out Josh's stream earlier. Mad at the Internet is the channel. I hope I'm supposed to announce that. Yeah. Oh, Siren Jag, I will definitely do that. Siren Jag says, hey, Nick, go to Twitter where I tagged you and like my tweet to Gen Con. How awesome would it be for Gen Con's new mascot to be named Hambly? It can happen with enough votes. I mean, whatever your opinion of the quartering is, and I know many of you don't like him, and that's fine. doesn't bother me at all. I have no interaction to base like or dislike of the guy on. We've had conversations and they've been just fine. But you're not going to bother me or not bother me with whatever your opinion is. Doesn't matter. It is funny if we can get Gen Con to change the name of the new mascot to Hambly. That's kind of funny. Oh my goodness. What an absolute... Why is everything going to garbage? Everything is going to garbage. I'm supposed to shill my shirts for just a second. So I'm going to shill the shirts for just a second. Let me just pull them up on screen. The shirts and the smug mug, which is the smug mug is like my favorite named thing, and I made it, which makes it even funnier to me. Hold on just a moment. I'm going to pull it up here. I'm going to pull up the thing. The window. Okay. So bear with me. I don't like doing the ad things, but everybody always tells me to shill the shirts. So we're going to shill the shirts for just a second. As soon as I can boomer through the tech to do it. Here we go. And let me... Almost got it. Here we go. This is on Teespring, the merch store. It's listed in the description. It's also a clickable link on Stream Me. If you want to check it out, I really appreciate it. But, you know, if this store is for people who like merch. If you don't like merch, don't check it out. Won't bother me at all. But, you know, we've got various items. T-shirts. The first T-shirt I put up is "This is reality, not Twitter, you giant idiot." It's a quote from my Mark Wade being sued by your boy Zach video. There's also a sticker up here with the phrase. All of these things come in like a billion colors. Okay, so don't let the color that's on display fool you. You can click on any of them, and they have. Well, I guess you can click on them. It'll load up eventually. See, they have all these different colors that you can pick. All that stuff. And there's different styles. Yeah. Different styles and different colors for each one. So there's that. Mainly, though, like, this is just great for me. This is a smug mug. Got the smug thumbs up on it. And on the back, it's got the Rekieta Law logo. So if you guys like this stuff, please check it out and buy it. If you don't. And if you want to see something different, let me know what it is. Send me a message and I can maybe make it happen. All right. I have shilled, and the shilling is done. So thank you so much for bearing with me on that. Let's switch over to the Roger Stone complaint. Oh my goodness. Here's the Roger Stone complaint. There's a lesson at the end of the Roger Stone complaint. I haven't read this. Indictment. I don't know exactly why Roger Stone was arrested other than, I mean, he was clearly arrested because he's an associate of Donald Trump. And, well, he talked to the police. Don't talk to cops. Let's see what we've got here. Lodian Loris says, "I'm 850 pounds. Where's my shirt?" No joke. Some of the shirts do come in 5XL. So if you're bigger than 5XL, buy 2 shirts and stitch them together. So there you go. All right. So this is in the United States District Court for the District of Columbia. And if you stay around to the end of the stream, guys, you get to watch a man die. So that'll be great, I guess. If you like watching people die, stick around through this. I don't think I'm going to read all of this document. We just want to get the gist of it. Did I get a new camera? No, it's the same one. It's probably just I've got better bitrate going tonight. So it's probably just running at 1080 for you. Here we go. Roger Stone. Rip Boogie. Okay, introduction. So this is a grand jury indictment. So if you don't know how grand jury indictments work, a grand jury is this great process where a group of people is picked, and then a prosecutor only typically goes into a room and tells them why they should charge you with something, and you don't get to defend yourself. It's the best system in the world. They get to use hearsay, they get to use inadmissible evidence, they get to use all sorts of things to prove that they have enough cause to bring you to trial. Then, of course, you have to do the next trial. But the fact that they get to use inadmissible evidence and hearsay, that bothers me. Because if the evidence isn't admissible at trial, then it shouldn't be admissible in a grand jury complaint. That's my personal opinion. Hold on. I got to eat this peanut butter cup because I'm starving. Trying to get to 850 pounds. There's Mundane Matt and Boogie. Fat guys seem to do well on YouTube. So do little tiny manlets like Destiny. And oh my gosh, I said it the other day, but I just have to give a shout out to my boy Jesse Lee Peterson. Amazing. For calling out that beta Destiny. Oh my gosh, that was funny. That was so funny. 40 minutes of comedy gold. I can't take it. And then so much more comedy gold if you go read the comments and find all the Destiny cock gobblers out there just really trying to make it out like Destiny somehow won that debate or that discussion or whatever, because he doesn't understand. Like, Destiny is so big brain that he doesn't understand that not everything is a debate. Sometimes you can just have a discussion. So Destiny, when he's asking you if you love black people, he's making a point that has nothing to do with your perception on like interpretations of racial grouping and collectivism. It's not that big of a point. You're sitting across from Jesse Lee Peterson, whom you obviously disdain and look down upon because you're such a ridiculous little bigot that you can't look at someone else and regard them as a human. But he's just asking if you love black people because he wants to get the point across that he loves everybody, because for him, the love of Jesus is in his heart. You idiot. You freaking idiot. You were trying to win a debate with a guy who was just talking to you. God, you're dumb. God, you're dumb. Oh my gosh. All right. Introduction. By in or around May 2016, the Democratic National Committee and the Democratic Congressional Campaign Committee became aware that their computer systems had been compromised by unauthorized intrusions by Seth Rich, and hired a security company to identify the extent of the intrusions. On or about June 14th, 2016, the DNC, through Company One, publicly announced that it had been hacked by Russian government actors. Oh yeah, that's great. The DNC, who had clear motivations in the 2016 election to link Russian tampering to an election, went ahead and announced that it was in fact Russian tampering that did it. That's what it did it. From in or around July 2016 through in or around November 2016, an Organization 1, which had previously posted documents stolen by others from U.S. persons. Oh, it's WikiLeaks. Entities in the U.S. government released tens of thousands of documents stolen from the DNC and a personal email account of the chairman of the U.S. presidential campaign of Hillary Clinton, the Clinton campaign. Oh, did they leak very factual, true documents about you guys being horrifying? Oh, that's weird. On or about July 22nd, WikiLeaks released documents stolen from the DNC. Yeah, but did they steal them? Who stole them? Between on or about October 7th and on or about November 7th of 2016, WikiLeaks released approximately 33 tranches of documents that had been stolen from the personal email account of the Clinton campaign chairman, totaling over 50,000 stolen documents. Roger Jason Stone Jr. was a political consultant who worked for decades in U.S. politics and on U.S. political campaigns. Stone was an official on the U.S. presidential campaign of Donald Trump until in or around August 2015. Notice, well before any theft is alleged to have occurred, and maintained regular contact with, I guess the discovery of said documents. He was with the campaign. So he was out in August of 2015. There you go. During the summer of 2016, Stone spoke to senior Trump campaign officials about WikiLeaks and information it might have had that would be damaging to the Clinton campaign. Stone was contacted by senior Trump campaign officials to inquire about future releases by WikiLeaks. Okay. By in or around August 2016, Stone was claiming both publicly and privately to have communicated with WikiLeaks. By in or around mid-August 2016, WikiLeaks made a public statement denying direct communication with Stone. Thereafter, Stone said that his communication with WikiLeaks had occurred through a person Stone described as a mutual friend, go-between, and intermediary. Stone also continued to communicate with members of the Trump campaign about WikiLeaks and its intended future releases. Now, it's important, guys, to pay attention. It's important, guys, to pay attention to the allegations of criminal activity. Talking to WikiLeaks isn't a crime. Talking to WikiLeaks about a release schedule for documents that were stolen and provided to WikiLeaks, also not a crime. Wait for the crime. After the 2016 election, the U.S. House of Representatives Permanent Select Committee on Intelligence, HPSCI, and the U.S. Senate Select Committee on Intelligence, SSCI, and the Federal Bureau of Investigation, CUCK, opened or announced their respective investigations into Russian interference in the 2016 U.S. presidential election, which included investigating Stone's claims of contact with WikiLeaks. In response, Stone took steps to obstruct these investigations. Among other steps to obstruct the investigation, Stone made multiple false statements to HPSCI about his interactions regarding WikiLeaks and falsely denied possessing records that contained evidence of these interactions and attempted to persuade a witness to provide false testimony to and withhold pertinent information from the investigations. Well, there you go. There's the two crimes. Important to note that Bill Clinton was charged with multiple counts of B in his impeachment. And also important to note that impeachments are not criminal matters, and impeachments are conducted by the Senate. And so Bill Clinton being found not guilty of paying witnesses to provide false testimony has no bearing on what a criminal case would have turned out were it not the President of the United States. Dante Lambio says, who would win in a cage fight between Hillary and Warren? Does Warren get to use a tomahawk, or does she get to use 1/10/24 of a tomahawk? That's the real question. Other relevant individuals. Person 1 was a political commentator who worked with an online media publication during the 2016 U.S. presidential campaign. Person 1 spoke regularly with Stone throughout the campaign, including about the release of stolen documents by Organization 1. That's WikiLeaks. Person 2 was a radio host who had known Stone for more than a decade. In testimony before the HPSCI on or about September 26, 2017, Stone described Person 2, without naming him, as an intermediary, go-between, and mutual friend to the head of WikiLeaks In a follow-up letter to HPSCI dated on October 13th, Stone identified person 2 by name and claimed person 2 was the gentleman who confirmed for Mr. Stone, so we can eliminate half of the population for person 2, plus a few extras who demand to go by ma'am. That the head of WikiLeaks had emails related to Hillary Clinton, which are pending publication. Background. Stone's communications about Organization 1 during the campaign. This is kind of boring, isn't it? I want to see a guy get shot. Here we go. Investigations. Stone's false testimony. Let's get to this stuff. I don't really care about the background. Stone's false testimony to HPSCI. In or about May 2017, HPSCI sent a letter requesting that Stone voluntarily appear before the committee and produce, quote, any documents, records, electronically stored information, including email, communication, recordings, data, and tangible things, including but not limited to graphs, charts, photographs, images, and other documents, regardless of form, other than those widely available, e.g. newspaper articles that reasonably could lead to the discovery of any facts within the investigation's publicly announced parameters. On or about May 22nd, Stone caused a letter to be submitted to HPSI stating that Mr. Stone has no documents, records, or electronically stored information, regardless of form, other than those widely available that reasonably could lead to the discovery of any facts within the investigation's publicly announced parameters. Don't clip what? I don't even know what I said anymore. Honor. Oh, it's watch a guy get shot. On or about September 26, 2017, Stone testified before HPSCI in Washington, D.C. as part of the committee's ongoing investigation. In his opening statement, Stone said, these hearings are largely based on a yet unproven allegation that the Russian state is responsible for the hacking of the DNC and the Clinton campaign chairman, and the transfer of that information to WikiLeaks. True statement. True statement. Stone further stated that members of this committee had made certain assertions against me which must be rebutted here today, which included the charge that I knew in advance about and predicted the hacking of Clinton campaign chairman's email, and that I had advanced knowledge of the source or actual content of WikiLeaks disclosures regarding Hillary Clinton. We know he doesn't. We know he doesn't. He'd be dead. He'd be dead already. In the course of his testimony, Stone made deliberately false and misleading statements to the committee concerning, among other things, his possession of documents pertinent to HPSCI's investigation, the source for his early August 2016 statements about Organization 1, that's WikiLeaks again, requests he made for information from the head of WikiLeaks, his communications with his identified intermediary, and his communications with the Trump campaign about WikiLeaks. Stone's false and misleading testimony about his possession of documents. During the testimony, Stone was asked, quote, so you have no emails to anyone concerning the allegations of hacked documents or any discussions you have had with third parties about the head of Organization 1? You have no emails, no texts, no documents whatsoever, any kind of that nature? Stone falsely and misleadingly answered, that is correct. Guys. Don't talk to the government. And if they do ask you this question, any questions, you show up and say, I'm going to plead the fifth. I'm not answering your stupid question. Don't talk to the government. I don't recall. Take a lesson from every Democrat who testifies who suddenly goes flat retarded and can't remember a single thing they've ever done in their entire life. Just take a note from them. They can remember nothing about anything important. And here you are, Republican after Republican after Republican goes to the FBI without a lawyer, always without a lawyer. They go before a Senate or a House committee and swear under oath. And then they sit there and they try and answer. Just say, I don't recall. I have no idea. I'll try and get back to you on that. Every Democrat does this. Every one of them. What is wrong with you people? James Comey. James freaking Comey. Note-taking, meticulous, careful, vaunted, super law enforcement guy James Comey couldn't remember where his dick was on Capitol Hill. Couldn't remember anything. Couldn't remember what front or back hole it was currently residing in. Even if it was his own front hole, he couldn't remember anything when it came to a detail. He remembered everything else in the world. But yet you dummies go up in front of these committees, just every single one, every single charge so far against a Trump campaign person has all been a false statement charge. All of them. All of them. Why? Because your brain isn't that good. You might have a document you don't remember. If you say you don't have a document and someone emailed you something, maybe you didn't ask for it. Maybe you didn't read it. Maybe you forgot to delete it. It doesn't, you might not think you have it. Just don't answer the question. They asked him to come voluntarily. He wasn't summoned. He wasn't charged. He wasn't anything. He walked up there and said, okay, I'm gonna sit down and get arrested. No! Just go on YouTube. Just go on YouTube and watch Trey Gowdy rip someone apart on the stand and pretend he's got a D in front of his name and pretend that whoever it is gonna rip you up on the stand because that's their job. You know they hate you already. What is wrong with these people? All right. All right. Okay. That is correct. Not to my knowledge. Not to my knowledge won't get you out of it, buddy. In truth and in fact, Stone had sent and received numerous emails and text messages during the campaign. 2016 campaign in which he discussed WikiLeaks, its head, and its possession of hacked emails. At the time of his false testimony, Stone was still in possession of many of these emails and text messages, including... And when was this? Let's go back to when this was. Hold on. When was this? May 2017. Including email from Stone to person one on or about July 25th, 2016. 10 months ago. Can you remember what email you sent 10 months ago? Can any of you remember specific email you sent 10 months ago? That read in part, get to the head of WikiLeaks at Ecuadorian Embassy in London and get the pending WikiLeaks emails. They deal with Foundation, allegedly. I assume the Clinton Foundation. B, email from Stone on or about July 31st. It said an associate of person one should see the head of WikiLeaks. Email from person one to Stone on or about August 2nd. So it's still the same time frame here. Still within a week. That stated in part, 8 days, 9 days. Word is friend in embassy plans 2 more dumps. One shortly after I'm back. 2nd in October. Impact plan to be very damaging. Very damaging. Dozens of text messages and emails beginning on or about August 19th and continuing through the election between Stone and Person 2, in which they discussed Organization 1 and the head of Organization 1. The email from Stone on or about October 3rd to the supporter involved with the Trump campaign. Remember, he's not even in the campaign. He's not even in the campaign anymore. He's been out for over a year at this point, which read in part, spoke to my friend in London last night. The payload is still coming. Well, that's a porn reference and you know it. Emails on or about October 14th, 2016 between Stone and the high-ranking member of the Trump campaign, including Stone's statement that WikiLeaks would release a load every week going forward. There you go. That's it. That's a crime, not remembering those 6 things. Maddie P on the road says, I love these happy bedtime stories. No anger. Stone's explanation of his August 2016 statements about communicating with the head of WikiLeaks was false and misleading. In truth and in fact, the first time Person 2 interviewed the head of WikiLeaks was on or about August 25th, after Stone made his August 8th, August 12th public statements. Similarly, at the time Stone made his August 26th statement, Stone had directed Person 1, not Person 2, to contract the head of WikiLeaks, and Person 1, not Person 2, had told Stone in advance of Stone's August 8th and 12th public statements that word is friendly in embassy plans, 2 more dumps. Word is friend in embassy plans, 2 more dumps, including one in October. At no time did Stone identify Person 1 to HPSCI as another individual Stone contacted to serve as a go-between or intermediary or other source of information from Organization 1, from WikiLeaks. Stone also never disclosed his exchanges with Person 1 when answering HPSCI's questioning about Stone's August 8th and August 12th statements. Lodi and Laura says, love this, unleash all anger, Corn wills it. Yeah, their load release schedule's a little slow. Troll with a Purpose says Wiki publicly stated that stuff, so yeah, but it doesn't matter. It doesn't matter because he could have had these communications, likely not illegal. I don't know what. He's not affiliated with the campaign anymore. He's been off the campaign for a year. For a year when these statements are made. When the alleged emails and stuff are happening, he's been off of the Trump campaign for a year. So he can contact WikiLeaks all day. I contend the Trump campaign can too, but he can definitely do it all day. There's no problem with what he did. The problem is just that he lied about what he did. So again, it's nothing after nothing after nothing. All of these cases are just because they lied. The cops can lie to you. Congress can lie to you. The CUCK can lie to you. Everybody can lie to you. But if you lie to them, prison. Get out. Okay. Stone's false and misleading testimony about requests he made for information from the head of WikiLeaks. During his testimony, Stone was asked, quote, what was the extent of the communication with the intermediary? Stone replied, I asked him to confirm that the tweet of WikiLeaks of the 21st was accurate, that they did in fact have Hillary Clinton emails and that they would release them. Stone was then asked, did you ask the intermediary to communicate anything else to the head of WikiLeaks? Stone falsely and misleadingly responded, I did not. Stone was then asked, did you ask the intermediary to do anything on your behalf? Stone falsely and misleadingly responded, I did not. Hey, Roger Stone, you should have said, yeah, I asked him to set up a meeting, because that's not illegal. I asked him when he was going to release the other emails. That's not illegal. In truth and in fact, Stone directed both Person 1 and Person 2 to pass on requests to the head of organization for documents that Stone believed would be damaging to the Clinton campaign. I wanted him to send me documents that would be damaging to the Clinton campaign. Also not illegal. As described, but he may not even remember this. As described above, on or about July 25th, Stone sent person one an email that read, "Get to the head of WikiLeaks at Ecuadorian Embassy in London and get the pending WikiLeaks emails. They deal with the foundation, allegedly." On or about September 18th, Stone sent a text message that said, "I'm emailing you a request to pass on to the head of WikiLeaks," and then emailed person two an article with allegations against then candidate Clinton released to her service as Secretary of State. Stone added, "Please ask the head of WikiLeaks for any state or HRC email from August 10th to August 30th, particularly on August 20th, 2011, that mention the subject of the article or confirm this narrative." On or about September 19th, Stone texted person two again, writing, "Pass my message to the head of WikiLeaks." Person two responded, "I did." Next day, person two, on an email blind copied to Stone, forwarded the request to an attorney who had the ability to contact the head of WikiLeaks. Okay, false and misleading testimony. I'm not going to read all these anymore. I'm just going to read the headers and see if there's anything interesting. False and misleading testimony. False and misleading testimony. Attempts to prevent person two from contradicting Stone's false statements. Let's see this. This is different. This is different. On or about October 19th, Stone sent person two an excerpt of his letter to HPSCI that identified person two as his intermediary to WikiLeaks. Stone urged person two, if asked by HPSI, to falsely confirm what Stone had previously testified to, including that it was person two. What? They redacted it. They missed a page. Goes from page 17 to 19. Good job, Pacer. God dang it. Why not wait to see what person two does? You may be defending yourself too much, raising new questions that will fuel new inquiries. This may be a time to say less, not more. Stone responded by telling person one that person two will take the fifth, but let's hold a day. Of course, I can't see what he wrote in the letter. So who knows? Who knows? I don't recall those pages. Yes, thank you. Thank you. Following person two's invocation of his Fifth Amendment privilege not to testify before HPSI, Stone and person two continued to have discussions about the various investigations into Russian interference. During those conversations, Stone repeatedly made statements intended to prevent person two from cooperating with the investigations. Let's see one. On or about December 24th, person two texted Stone, "I met the head of WikiLeaks for the first time this year, September 7th. Docs prove that. You should be honest with FBI." No. You should not talk to the FBI. There was no back channel. Be honest. Stone replied approximately 2 minutes later, "I'm not talking to the FBI, and if you're smart, you won't either." But you went in front of the House committee. Wah! Yeah, correct. You shouldn't talk to the FBI. It's not, by the way, that's not illegal to tell someone they shouldn't talk to the FBI. Encouraging them to lie or obstruct justice, yes. Not talking to the FBI is not an obstruction of justice. On or about April 19th, wrote in an email to person two, "You're a rat, a stoolie. You backstab your friends, run your mouth. My lawyers are dying, rip you to shreds." Stone also said that he would take that dog away from you, referring to person two's dog. On or about the same day, Stone wrote to person two, "I'm so ready. Let's get it on. Prepare to die, expletive." On or about May 21st, person two wrote in an email to Stone, "You should have just been honest with the House Intel Committee. You've opened yourself up to perjury charges like an idiot." Stone responded, "You are so full of expletive. You got nothing. Keep running your mouth and I'll file a bar complaint against your friend, the attorney who had the ability to contact the head of Organization 1. Well, there you go. There you go. Those are the counts. False statements. Witness tampering. Witness tampering. I actually don't think they got anything on witness tampering here. Don't talk to the FBI. Let me witness tamper everybody on Earth. Don't talk to the FBI. He didn't tell him to lie. Where did he tell him to lie? Oh, here we go. No, see, we don't have... Let's see. On multiple occasions, including on or about December 1st, Stone told person 2 that person 2 should do a frank Pentangeli before HSBI in order to avoid contradicting Stone's testimony. Frank is a character in the film The Godfather 2, which both Stone and person 2 had discussed, who testifies before a congressional committee, and in that testimony claims not to know critical information that he does in fact know. Just don't talk to the FBI. On or about December 1st, Stone texted person 2, and if you turned over anything to the FBI, you're a fool. That may be true, unless it was a response to a direct subpoena. Later that day, person 2 texted Stone, you need to amend your testimony before I testify on the 15th. Stone responded, if you testify, you're a fool. Because of Trump, I could never get away with a certain, my Fifth Amendment rights, but you can. I guarantee you, you are the one who gets indicted for perjury if you're stupid enough to testify. The Dr. Gnome says, why is asking for WikiLeaks emails illegal? It isn't. It isn't. It isn't. It isn't. It is not illegal at all. I mean, it's stolen, but what's the huge hubbub about it? Nothing is illegal about that. It's simply because he lied to a congressional committee about something he didn't have to lie about. He didn't have to lie about. So, there you go. There you go. Just don't. Never talk without an attorney, and pretty much. That's it. That's it. All right, should we watch a guy get shot? Let me find it real quick. We've got is this it? Where is this guy? Where's this guy? Where's this guy? I tweeted about this the other day, but I didn't look at the YouTube. Where is it? Why is it so hard to find? Oh, here we go. Here we go. I'll get it pulled up on stream here. Just a second. My boomer powers have activated. This. Almost there. Now let me just go with this. Oh, here we go. We'll get the whole video in the frame. Okay. So, oh, I gotta throw on headset. So watch this. This is a little bit of a change of pace for my channel. Because if you are familiar with my content, I'm very critical of police shootings. Very much opposed to the state being able to kill the citizenry. In general. Now, I don't think the state doesn't have a right to. Let me be clear on that. Like, I think a state has a right to do the death penalty and stuff. I don't have faith in the state to do it competently in most instances. And so I'm critical of shoots. I'm critical of that type of stuff. But let's take a look at this one, and I'll give you my opinion on it after one more chat. The Dr. Gnome says, no, but does WikiLeaks having those email make them criminals? like a criminal offense, but giving it away for free. It's only illegal to have those emails if you illegally obtain them. If someone else stole them and gave them to you, you're probably fine. But you should always check with a lawyer in your jurisdiction. Don't take what I say as legal advice. All right, here we go. Make sure you guys can hear it. Make sure I can hear it. And make sure my volume is coming through my headphones. Okay. Here we go. Warning, graphic content. Oh, if you don't want to see a man die, stop watching.
The principal is the police. You don't have jurisdiction over here.
I do. I'm actually the school.
Me to leave.
Listen to me.
If the principal has not asked me to
Listen
leave.
to me. You're gonna end up.
Go!
That's a smash the patriarchy
You're
shirt.
under arrest.
Let go
You
of me.
are under arrest.
Let go of me.
You are under arrest.
Let go of me.
Code 3 first.
Get out of here.
Okay. So if you didn't catch what just happened there, let's check it in just a second. Oh, wait, let's check his claim. It's hard to make out because they're bleeping out a lot of stuff that he says. And you'll notice this, or I notice this. I don't know if you guys do or not. About leftists. About leftists in general. Have you noticed, and I noticed this with covering the Matt Loader lawsuit against, or the Hambly versus Loader lawsuit is where I saw this very specifically. Do you notice that that people on the left have to use profanity? Like they have to. They drop the F-bomb so many times. And I have no problem. Like, don't misunderstand. I have no problem with the use of profanity, but they think that it makes their point. Like, this guy is dropping so much language immediately. He's got 2 cops. So it's hard to make out what he's saying, but he does say the principal hasn't asked him to leave. Well, it doesn't really matter if the principal asks you to leave or not. If you're there and anybody with authority to ask you to leave does, including cops, you might need to leave. You might need to leave. They could be wrong, but in the moment, you might need to leave, because that's how you go home at night. But here we go. Let's watch the slow-mo. So they've taken him outside because he's, at a middle school. Here we go. The sound, of course, is stopped. They put him against the wall. He basically starts saying some crazy stuff. Hold on. He's already reaching. Is he already reaching? It looked like... Let me get back there. Watch his right hand here, because I'm pretty sure he's already reaching to a pocket for the gun. Yep, he's fiddling. His hand goes into the pocket. He's pulling the... or holster. He's grabbing for the gun. There, he's got it. There, he's got it. Put him down. Put him down. Put him down. That's a good shoot. Good job, officers. The officers, like, again, I'm really, really critical of cops because I see cops doing bad things, right? This part of my job is to find the problems with cops, to find that and point it out. This guy, and so very critical. He's already got his hand in his pocket here. I don't know if the gun's in his pocket. I think it's in a holster on his hip, if I had to guess. But yeah, this is one of the times where they seem to do everything right. They seem to be calm and de-escalating the situation. Well, the audio came in like a wrecking ball there, so I apologize for that. That's it. Let me just say again, good job, officers. He gets shot while he's on the ground, while the other officer is wrestling with him, or while the one officer is wrestling with him. He pulls He pulls the gun. The one officer clears himself from the gun. It looks like to me he clears himself from the path of the gun that's drawn, and the officer who has him must pull the trigger, as best I can tell, while he's on the ground. I don't know that for a fact, but it's really, really tough. But yeah, his right hand stayed in his pocket prior to that. I don't know if the weapon was in his pocket or if it was on his hip, but guys, if a cop's talking to you, having a hand in a pocket is a bad situation anyway. The fact that those cops were calm while he had his hand in his pocket in the first place is really kind of shocking to see. Really shocking to see. So, you can hear his kid yell, "Dad." That's awful. That's awful. That's the sad part of these stories. No, no kid should have to deal with that. I don't know what that guy was doing. Why you would bring a gun to a school, which is absolutely unlawful. Not that it necessarily should be, but it is. But also just don't wear a Smash the Patriarchy shirt ever. You're just asking. You're asking for, as the streamy chat is saying, you're asking for Darwin to step in, basically. But yeah, real turd bag. If you get yourself killed in front of your kid for your own bad actions, you're awful, because that kid's gonna be messed up because of the dad. Where Tiger Ray says, care to read the statement from the Antifa group he was a part of? Yeah, I do. I do want to read it. I don't know how you can get it to me. Where Tiger, can you link it in the chat? I don't know where the kid yells dad. That's what someone said on Stream Me. I don't know if that's true. I didn't hear it. It's so hard to hear. Don't dead air me. Don't dead air me. I'm just waiting for a link. Waiting for a link. Okay. What? Where are we? Okay, hold on. This is top shelf radio. This is top shelf radio. Does anybody have the link to the Antifa group's statement? I can maybe look it up. Antifa Eugene, Oregon shooting. I'm not seeing it. Oh my god. Ugh. I went to the Eugene, Oregon Antifa site. What a disaster. Is that what Bronx Blogger does? Does he do that stuff? All right. Oh, here we go. Here we go. Thank you. Thank you for that. Let's get this over here. Oh, Sorry, boomer hour. We're centered, sort of. There we go. Okay, so in memoriam, Charles Charlie Landeros. 1988 to January 11th. Here we go. Here we go. This is just miserable, guys. Just miserable. All right, so here's the quote. Here's the quote. Do not let anyone quench your fire. Do not let them well, I mean, if you would have let them quench your fire, you might not have bullets. Sorry. Do not let anyone quench your fire. Do not let them dismiss your love, nor pacify your rage. My love, do not water yourself down. That's Love and Rage. Poem by Charlie Landeros. Guys, this has to be a fiction, right? Hashtag Love and Rage for Charlie. He's a poet. He's a poet and an Antifa member. I mean, come on. Come on. Charlie Landeros was a 30-year-old person who was shot and killed by unknown Eugene police officers on the morning of January 11th, 2019. Charlie was born in Hong Kong and migrated with their... And there's a footnote. Charlie's gender pronouns are they, theirs. Pronoun in the bio is all you need to know. Pronoun in the obit, and you gotta quit. I don't know. What is it? He's got preferred pronouns in the obituary. His pronoun is his. He doesn't have a preference anymore. His preference was bullets. Migrated with his family to the U.S., where Charlie was raised on Kalapuya land in Eugene, Oregon. Charlie attended Cascade Middle School, also where they were tragically killed yesterday. So he's an alumni where he was tragically killed yesterday. It's not they were. He's not plural. And graduated from Willamette High School, enlisted in the Army at age 17. Upon being honorably discharged from the military, he attended the University of Oregon. Charlie was most proud of being a parent to two daughters, ages 10 and 12. And because of his own stupidity, they're now fatherless. Because he never let his rage be quenched. What a freaking moron. In addition to the children, Charlie Landeros leaves behind his partner, parents, a younger brother, and numerous other family members and friends. Quote, the biggest thing is trying to figure out how to live without my older sibling, brother. My lifelong support. Charlie has always been there for me when I needed them. This is a quote, but never again. I have accepted this, but I still don't know how to go from here. He drew a gun on cops, said Joseph Landeros, Charlie's brother. The details of this homicide are still largely unknown. No. Oh, they're pretty clear. The details are pretty clear. What is known is that Charlie had recently enrolled his daughter at Cascade Middle School as the custodial parent. The custodial parent. So, partner is not the parent of the children. Whoever the partner is. The school contacted Charlie regarding his child's safety, and Charlie went to the school to ensure the safety of this child. We also know that Charlie was shot multiple times by Eugene police officers several feet in front of the main entrance to the school. Yeah. The family of the deceased requests that the community recognize that deaths like Charlie's are neither accidental nor uncommon. Nope, that one wasn't accidental at all. That was Charlie's choice. Like Sophie's Choice, only a lot stupider. Charlie's Choice. Charlie drew a gun on cops who weren't being aggressive, who weren't escalating. They were attempting to de-escalate. Those cops, you know what sucks? Those cops were doing every single thing we want cops to do. They didn't have guns drawn on him. They weren't tasing him. They weren't beating him. They weren't screaming at him. Every single thing we want cops to do, they were doing. I can't take it. Charlie was the beating heart of every project he was involved in. The beating heart of our community, said Ariel, Charlie's partner. We will need to learn how to regrow from that. Are you royalty? Because Charlie's reach was so big. Huge. His reach. Huge. Puro Resu says he was there to abduct his child from school. Super Iron Bob says he wasn't the custodial parent. Oh. Uh-oh. Uh-oh. While people of color comprise 38.5% of the U.S. population, they make up 51.5% of those killed by police. Was Charlie a people of color? Did I miss that? Was Charlie a people of color? In spite of this staggering statistic, there's no national database that police departments must submit a record to when they complete an investigation after an officer shoots a civilian. Let me help investigate this one. Good shoot. Good shoot. Good shoot. Okay, it said he was born in Hong Kong, but he looked white to me, so I don't know. Like, Landeros is not a Chinese name, is it? I don't know. I mean, he just, to me, I guess... Are they going with, like, racial purity? He looked kind of white to me. I don't know. Okay. Despite law enforcement's willful ignorance in the last several years, they're making this about police violence. This one isn't. There are cases to be made about police violence. Like the guy in Arizona who got shot in the hallway of a hotel. That's bad police violence. This is the police violence we want. When someone pulls a gun on cops, when they're just doing their job in the right way. In the last several years, there have been far too many headlines describing people of color being shot and killed by police. The lesson learned, the experience of dealing with police in America is different for whites and non-whites. I'm sorry. You don't get to mix Asians in with as non-whites. Because you're talking about a statistic that is absurdly low for Asians. Asians shot by police is really, really low. It's mostly black and white. It's mostly black and white. Charlie was mixed Filipino and Mexican descent. There you go. There you go. The amount of Filipino Mexicans shot by cops is literally Charlie. I'm pretty sure. Like, it's embarrassingly low. Unlike the investigation into the police shooting death of fellow veteran Brian Babb, the family demands that this investigation be transparent, unbiased, and thorough. Okay. Here, let me do that for you. Good shoot. Donations to fund the independent investigation to Charlie's homicide by police can be made at cldc.org/donate, the Civil Liberties Defense Center. And please note that your donation is in memory of Charlie Landeros. Let's see. Now, here we go. So here's the link. Here's the link to donate to the specific cause, right? Donations to fund the independent investigation to Charlie's homicide by police can be made at here. Here's your donation amount, contact info. Notes or additional comments. It doesn't suggest that this is exclusively for the investigation. What you're doing is going ahead and donating to the Civil Liberties Defense Center General Fund. We'll see. We'll see. There you go, guys. Well, that's that. That's that. I don't donate to anything, much less that. That's not true. I donate to several charitable organizations, but not for anything like this. Holy cats. Okay, I got a couple chats to read, then we're going to wrap it up. Blue Samurai Zero said, the PD's YouTube has a better slow-mo. 4th playthrough with circles on critical things. Gun was in pants, leg pocket. Other behavioral issues. Custody battle. He tried to dodge cop and leave. Cops restrained. He shoved cop from wall. 2 shots at standing cop. Well, there you go. So he got 2 shots off while the cop was standing. So they waited until being fired at. Those cops went so far above the so far above what we would ask a cop to do that it's insane. It's insane. Matt Field says the FBI knew again. FFS. The DCV Titan says, I do believe his rage was pacified. Yep. His rage is now cold and stale. Blue Samurai Zero, correction. Better Vid was not on police department's YouTube. Here, start time set for freeze frame playback. Labels in video on paused frames. Okay, so let me, let's see if we can. Blue Samurai Zero says, my phone is ringing. It's the cucks, but they keep saying FBI. Should I talk to them? No. No, never talk to them. Why can't I select this? Oh my goodness. I hate everything about this. Just a second. I'll see if I can pull up this video real quick. It's not working. Streamlabs doesn't want me to actually click the link. Oh, wait. What am I doing? It's, oh, there's another statement from the police. That's good. Oh, here's the... Oh, the FBI knew about this guy. They knew about this guy specifically. Gotcha. Gotcha. Here we go. Okay, so here's the police response. We'll read this one. We'll read this one time and then we'll wrap it up. Sorry. Merc donated. Keep up the good work. Hit me up. It's juicy. Will do, buddy. JW says, just donating because I love what you do. Thanks. Thanks, man. I really appreciate that. Really appreciate that. Okay. The Eugene Police Employees Association would like to address the Civil Liberties Defense Center's careless response to the shooting incident between Charles Landeros and our officers on January 11th, 2019. CLDC is trusted by many in our community to be a voice of truth and reason regarding the shooting death of Charles Landeros. The CLDC provided false and unconfirmed information to the public and a grieving family, which has caused irreparable harm. Hey, CLD, stop trusting these organizations. Stop trusting them, which has caused irreparable. Don't trust cops either. Don't trust anybody. CLDC requests equality, hope, justice, and innocence until proven guilty, yet irresponsibly reported inaccurate information with no factual basis. As the Landeros family awaited the facts of the case, CLDC proclaimed within hours of the incident on their website and via social media that the family's son, brother, father was murdered by our police officers and has continued to proclaim this was in large part because of the color of Charles Landeros' skin, which is definitely not true. Like, again, even in the most charitable, like, pro people of color view you could take, there's no way that makes any sense. At the time of the CLDC's first public statement, The investigation had just begun, yet the CLDC launched a campaign of misinformation. One example of misinformation they irresponsibly provided the community and to the Landeros family is copied directly from a quote on the CLDC website, which was posted not even 24 hours after the incident. Quote, "We also know that Charlie was shot multiple times by Eugene police officers. However, the investigation showed that Charles Landeros was shot one time. The first two shots heard by witnesses were actually fired by Charles Landeros as he attempted to shoot our officers, which is clearly seen on body camera footage. Some other facts learned about the investigation. Charles Landeros pulled his firearm out first. He whipped it out first, as I'm sure he normally does. Charles Landeros shot at our officers first. Charles Landeros was then shot one time in response. Our officers did not display/retrieve any weapons or tools prior to Charles Landeros pulling out his gun. Our officers were not aware of Charles Landeros was armed until he tried to shoot them. Within seconds of Charles Landeros being told he was under arrest, he shot at our officers. Just 2 days prior to the shooting, Charles Landeros posted via social media, quote, 'Time to start killing pigs. S to spit. There is no option. Get out. Get out.' Ugh. God, disgusting people. As a trusted local organization, the CLDC should have waited for information rather than launch a hate campaign against police officers. Misinformation distributed by the CLDC led to hundreds of hate-filled social media posts, outrage at city council meetings, and protests. CLDC could have brought some amount of closure to the Landeros family and our community with correct and honest information. Instead, they unnecessarily caused additional pain and grief for an already grieving family and a shocked community. And let me just say, if that shirt said build the wall, journalists wouldn't be able to stop the fellatio of each other. They wouldn't be able to stop. All of the fired journalists would still be tweeting for free. They'd be wasting everyone's time for free. Oh my gosh. Just disgusting. All right, guys. S means spit, as opposed to F for respects, Zarther. Oh, there's more. There's more? There's no. Oh, there's more of this statement. Okay, sorry, there's 3 more paragraphs. Lauren Regan, the attorney representing the Landeros family, requested on January 12th that no law enforcement officer communicate with the family. She then criticized the police at the press conference on January 14th for not contacting the family. Well, that was stupid. Additionally, Ms. Reagan stated at the press conference, Reagan, and we also know within our own community that although the Eugene Police Department and Springfield Police Department have failed to compile data with regard to race, that race has been a prevalent problem and issue with regard to, stop and frisks, as well as violence against people of color. Eugene Police Department does, in fact, compile data related to race and provides regular updates to the Eugene Police Commission. Eugene Police Employees Association has patiently waited to respond to CLDC's actions out of respect for the investigation to be completed. As the investigation has now concluded, good shoot, we hope that the Landeros family finds some closure in knowing exactly what happened. Yeah, they know. They know, okay? They know. They already know. Just as our community, including the CLDC, demands that our police department takes responsibility for our actions, we also demand the CLDC takes responsibility for theirs. Delivering a message to the public that described this incident as a, quote, murder of another person of color by law enforcement was incredibly unprofessional, and the EPEA won't idly stand by while the CLDC continues to spread this message. While the loss of life was tragic, we know our officers took necessary action under very dangerous circumstances to protect themselves and the public. They did not deserve the added stress that the CLDC created, nor did the community. Our officers Our officers are members of this community too, and we are thankful for their bravery, integrity, and professionalism every day. Well, I don't know about every day, but I'm thankful for it on this day because those guys did everything right. Those guys did everything right. Naomi Yashin Cult says, have you seen how they're trying to turn the person leading the student protest to the next David Hogg? LMAO, but nobody cares enough? S? No, I don't care either. Hey, Naomi, now correct me if I'm wrong. Aren't you the person who was in here the other day, like, having a giant hernia about the fact that I was talking to someone who you determined is guilty of wrongthink? Like, weren't you spamming my chat with a bunch of boring messages? Was that you or was that someone else with an anime avatar? Am I mixing those up? I think it might have been you. I don't know, though. Huh. Anyway, thanks for watching. Thanks for watching, Naomi. I appreciate the views. Drop me a super chat sometime. All right, guys. That's what I got for you. I appreciate you guys coming out to watch. Streaming a little over 3 hours now, so I'm going to take a pause. I'm going to take a breather. And I don't know what we're going to do tomorrow, but it'll be fun. And Wednesday will be fun. The big confirmed show I have this week is Friday. Friday's big brain panel, where it will be me and 3 other lawyers. We'll all be connecting remotely, so don't try to kill us. Oh, there are a couple streamy donations I need to read. You can't kill us all because we'll be remotely connected. But come check it out. There are 3 streaming donations. Knitting Killer says, Nick, you're the only lawyer I've ever had respect for and believe is honest and has integrity and actually like. You're a very cool guy. Thank you for sharing so much knowledge with so much entertainment. Bless you. Bless you back, Knitting Killer. I really appreciate that. Thank you so much. Next, we have Some87 says, play the donut operator video he did of the shooting. He goes into detail on what happened. I'm not going to play Donut's video only because I don't want to take Donut's content. Go watch the donut operator video of the shooting if you want to get his detail on it. I don't want to take it from him and take, not that he needs, like, not that I'd be taking views. He's a very popular guy or whatever. But yeah, check out his content on your own. I don't want to take views from him for that. I'll take them from the news site that posted it because they're, news sites, so who cares? Let's see. Next is Redacted WSF says, I know you said police brutality can most often go too far, but don't you think it would be really cool if cops yelled out, I am the law, before dispatching unruly commies? Yes. I do think that would be very funny. I do think that would be great. That would make me really happy if they did that. And then finally, Lodian says, so to confirm messages you sent previous, always talk to the FBI even when they aren't involved. No, never talk to the FBI. Never talk to the FBI. When you do, talk through a lawyer and shut your mouth and listen to the lawyer. And get a good one. Oh, look, Naomi's sad that I made fun of her. I'm a racist. Okay, sure. Whatever. Naomi, you're an idiot. So there you go. Why don't you go watch the streams where I argue with my audience about police violence against people of color instead of making baseless claims? You'll probably find that many of them would disagree with me and be mad about it. But, go ahead. Call me a racist all you want. I don't care. You have an anime avatar. You're pointless. You're just a boring Bronx blogger rim jobber. Go for it. Go do what you're going to do. No one cares about you. No one cares about any of you. You're just so boring that you have to go on to streams of other people to try and get anyone to just listen, and we still don't, because your words don't have any effect on me. So that's okay. Doug Confair says, Naomi, be gone, thought. Get out. Get out. Oh my gosh. All right, guys. All right. I'm alt-right POS. Yes. My views where I like openly advocate for open borders, didn't vote for Trump, am completely opposed to police violence against black people. So alt-right. You got me. You got me. Do some research, you dumb cunt. Oh, go home, Naomi. You're more drunk than me, and that's pathetic. All right, guys. Y'all have a good night. Peace.